All right, good morning, ladies and gentlemen. I am Claudia Robinson, and I'm the judge that's presiding over magistrates this morning. I'm going to go ahead and give you some brief explanations as to what the purpose of this hearing is, procedurally how this hearing is going to go, and then we're going to go ahead and get started momentarily. This is a non-adversarial hearing, which means that it's basically not up for too much of a debate. The state attorney is present and the public defender is present for those of you that have sought appointment of the public defender or have been provisionally appointed to the public defender's office. If you're being held no bond on a capias or on a violation of probation, I can't touch those, unfortunately, but I will try to give you as much information as possible. And what the purpose of this hearing is to find probable cause on those affidavits of the new arrest or any ad charges, and to set the bond on cases where it is appropriate. So, with that being said, we're going to go ahead and call three out of turn really quickly, with everybody's indulgence. Arton Bowen. Okay, how are you, Mr. Bowen? Can I get... Thank you. How are you, Mr. Fabricant?
Huh?
How are you, Mr. Fabricant? Okay. All right, Mr. Bowen.
Good, Judge. How are you? I'm sorry.
Sir, you're charged with trespass of an occupied structure or conveyance. Any probable cause argument, Mr.
I don't get none of that. What charged me? Trespass what?
It's a trespass of an occupied structure or conveyance. I find probable cause for that charge, and the convenience bond right now is $100. State any...
Your Honor, I'm not seeking any kind of modification on the bond.
Mr. Fabricant?
Judge, if I can have 1 second.
Sure.
Judge, this probably needs to be transferred off to Lerner Ring.
Okay, very good. So we're going to go ahead, if we can go ahead and transfer it over to Lerner Ring. In the meantime, sir, your bond is set at $100. Thank you very much, Mr. Bowen. Be well and have a good day, okay?
Okay, you too.
What?
Justin Swain.
There's an ad charge?
All right, Mr. Swain, you are charged. You have a capias for case number 1601452-4CF10A. The bond was set at $750 by that division judge. I find probable cause for that capias since this was already signed by the division judge. And it was an ad charge. I'll leave I can't disturb the bond for $750. But the good thing is that you're going to see the division judge, Mr. Swain, on January 18th. Okay? Daniel Carter.
How you doing, sir?
All right, Mr. Carter, you have two counts. Count one is in home invasion with a firearm or other deadly weapon. And count two is abuse of an elderly or disabled adult without great bodily harm. Mr. Afzal, any probable cause arguments?
Already done.
All right, I find probable cause for count one, the home invasion, and count two, abuse of an elderly or disabled adult without great bodily harm. Mr. Linder, as to bond.
Your Honor, on count one, the state would be seeking a no bond as it is a punishable by life offense. Your Honor, on count two, I would advise the court, Mr. Carter's criminal history, 2008, burglary of a structure with damage over $1,000. He was sentenced to 5-year state prison as a habitual offender. 2004, resisting without violence, unlawful use of false name ID. 2002, burglary of a dwelling. He violated probation. Dealing with stolen property. 2001, with a violation of probation. Your Honor, based on his criminal record and the level of violence alleged in this case, I would be asking for a $20,000 bond on count two. Obviously, we'd be seeking an order of no victim contact.
Mr. Barbaric?
Judge, I don't know if the court's inclined to hold him no bond, but this would be a first-degree punishable by life, which is subject to an Arthur hearing. I don't want anything that's done here today to affect that.
Okay, so you want me to just leave the, okay, so on count one, we're going to go ahead and defer for that Arthur hearing to occur within the division. As to count two, You want me to defer that one to the division as well? Because he's going to unfortunately get stuck with whatever I give him on count 2 if I do. He's going to be held no bond anyway, so he's not going to be going anywhere, but it's up to you if you want to go ahead and set a bond on count 2.
Judge, what I would ask is, would the court set some kind of minimum? And I understand the nature of the charges are great, but he will be being held on the no bond. I don't know if the court, with regards to count 2, would set some minimum bond so that if there's a bond set on the other case, he may possibly be able to bond out. But it may take him time to get to the division by the time that they get the file open and that. And again, I understand he's not going anywhere.
Okay. The bond on count 2 will be $15,000. Thank you very much.
Thank you,
Your Honor.
Thank you, Judge.
That's right, and I'm going to order no victim contact. I apologize for that,
Thank
Mr.
you,
Carter.
Judge.
I'm going to order that you have no victim contact with the victim in this case. What's the victim thing? Mr. Linder?
One moment, Your Honor. Is Louise Pfister?
All right, so I'm going to, Louise Pfister?
That's what, yeah. That's what
Okay, so I'm going to order that Mr. Carter have absolutely no contact with Miss Louise Pfister. You understand that, Mr. Carter? All right. All right. We're going to take another one out of turn. We're going to do Dugera Ilarian. And the next one that we're going to also do out of turn is going to be Oscar Orrego. All right, Mr. Ilarian, welcome, sir. You have three counts. Count 1 is DUI causing death to any human. Count 2 is a DUI causing death to any human. And count 3 is vehicular homicide to a person or a viable fetus. The state attorney is present, sir, and they have filed a motion for pretrial detention.
Judge,
Basically gives.
I just want to know if he has an attorney or not.
Oh. Sir, have you sought appointment of the public defender's office?
I haven't talked to my attorney yet, ma'am.
Okay, do you have?
But yes, I do. Yes, I do have an attorney.
Who's your attorney,
You
sir?
don't know I'm in jail.
Who's
Excuse
your
me?
Who's your attorney, sir?
My attorney?
Yes.
Franklin Gordon.
Franklin Gordon.
Yes.
Does he know that you're here?
No, ma'am.
He does have a right to have his counsel here. I can look. Do you know where he's based?
Excuse me?
Do you know where he's at? Do you have a phone number for him?
No, my phone. I don't remember his phone number by head.
Do you know if he's based in Fort Lauderdale, Miami?
Miami.
I'll check the phone box.
You have a job?
Oh, God.
Sign right now your phone number.
His name is Franklin Gordon.
Yes.
Yeah, I checked
But
the
this case,
Florida bar. It's gonna be that name.
this case been on since 2015. I just got noticed that I got a
Okay, no, and I
warrant.
don't want you to talk about the facts of the case, sir, because anything that you say can and will be used against you. All right, what do you want to do?
Judge, we filed our motion. No attorneys filed on him. This case has been pending. We've had a capias looking for him since for almost a year now. Through the U.S. Marshal Service, we're able to locate him and he was arrested. We filed our motion for pretrial detention. If the attorney files a notice, we will
Alex Rodriguez?
as well. After the court finds holds him pretrial detention today, I will be in touch with Judge Merrigan's office. We'll start hearing within 5 days.
Judge, my only thing is this, that even though he's declined the public defender, part of the rules, he has a right to consult with counsel in regards to these charges. The seriousness of the offense is given an opportunity to contact who he
I could be
says
my
is-
own counsel. I don't need no counsel.
All right, sir, well, here's the deal. An attorney, sir, would know the system a little bit better than you, perhaps, and the state has filed a motion for pretrial detention, which means that you would be held until you go see the division judge, which could take anywhere between 5 days. It depends on the judge's availability and on the docket. So you wouldn't be getting a bond today. If you had an attorney, however, perhaps that attorney could make some arguments to the court that would perhaps change that situation in some fashion. Do you want an opportunity to speak to your attorney, or do you want to proceed without an attorney, sir?
I want to proceed without attorney, ma'am.
You want to proceed without an attorney? All right. Mr. Larian, as it relates to the magistrate hearing, I do find probable cause for counts 1, 2, and 3, seeing as how those warrants were already signed and those cases were already signed. And, not in custody cases was signed. And I'm going to go ahead and, based on the state's motion for pretrial detention, we're going to go ahead and defer this over to the division judge to go ahead and set the bond.
So it would be held no bond at this point.
All right, Your Honor.
Until we hear before.
That's correct.
Okay.
All right?
Thank you, Judge.
Thank you very much. Good luck to you, Mr. Larian.
Okay, ma'am.
David Johnson. Mr. Larian. Mr. Johnson.
Oscar Orrego.
Santiago.
Well, they're going to set up one for you today. Usually they, standards on stuff.
All right, sir, your attorney is present. And sir, you're charged with 1 count of fleeing and eluding a law enforcement officer. And your count 2 is reckless driving as a first offense. Counsel, do you have any probable cause arguments that you'd like to make?
Yes, Your Honor. Good morning. Ernest Perez with Brian Jordan. I had a chance to go over the probable cause affidavit. With respect to the probable cause argument, it's an identity. In the probable cause affidavit, the officer states that there was a pursuit of a person on a motorcycle, and that person was never, the stop was never effectuated. So the officer was unable to obtain the identity of the person driving the motorcycle. The officer then goes, I guess he pulls the date information, sees that Mr. Orrego is the registered owner of the motorcycle, and he presumes that Mr. Orrego is the one driving the motorcycle. Never in his probable cause affidavit does he state that Mr. Orrego, the person driving the motorcycle, is the same person that Mr. Orrego, the person on the David information, is the same person as therefore, it's our argument that identity, which is an element of the crime, is not established by probable cause, and that cannot be held at this point.
Richard Benso.
Mr. Linder?
2 things, Your Honor. One, I would argue the question of whether there's probable cause to detain Mr. Orrego at this time is based on the not in custody information filed by the state, which produced the capias issued by the clerk's office. Essentially, the defense asking the court to find no probable cause to arrest on a case where the state has filed an information and a valid capias issued would be tantamount to seeking a motion to dismiss before the court at this time. Additionally, Your Honor, I can, as an officer of the court, I've reviewed, and this charge was filed based on more than just a probable cause affidavit. I can tell you, and I'm reviewing a supplemental report that I'd be happy to show defense counsel, where the arresting officer states, and I quote, "A computer check revealed the suspect was the sole registered owner of said motorcycle, Oscar Orrego. Furthermore, I located photographs in parentheses, DHSMV and Miami-Dade mugshot of registered owner Orrego, and observed them to be the same individual who I observed operating the aforelisted motorcycle. I completed an out-of-custody probable cause affidavit and uniform traffic citations charging him with the 2 of the charges that are before the court today."
I'm also, I have to look at the 4 corners of the
The 4
probable
corners,
cause
that was going to
affidavit.
be my follow-up.
I don't
to
see that there was anybody else on the motorcycle.
There was no one else on the motorcycle.
Actually,
Right. So,
My argument is basically there was no identifying documents that were given on the date that this officer observed the motorcycle in motion. What the officer does, he goes on David, he looks up who the registered owner is, and he sees that the registered owner is Mr. Orrego. Again, nowhere in the 4 corners of the probable cause affidavit does it mention that Mr. Orrego was the person that he observed driving the motorcycle on this day.
Your Honor, the court can consider other reports provided by the state. I mean, let's think about it this way. Let's say I didn't have this supplemental report, Your Honor, right now that I could show the court, then the court would give 24 hours for the state to perfect, and I would come back with the report that I have right now.
I believe that's more, your argument may be more of a motion before the division judge, so I'm going to respectfully deny. I'm going to find probable cause for the count 1 and count 2.
Yes, Your Honor.
Nevertheless, on bonds, what are we doing? What's the state's?
One moment, Your Honor. I just need to check his record.
Naturally, that would be taken into consideration as far as the bond is concerned.
Yes, Your Honor. Thank you.
Your Honor, the only thing I see in 2011 out of Dade County, he had a resisting without violence that he went through a diversion program. It appears he successfully completed it and the charge was dropped.
Your Honor, and just for the record, his family is present, his mother and father are present, his girlfriend is present. Mr. Orrego is currently self-employed. He is a mechanic. He is actually also, he's going to vocational school. He's working on 2 licenses to work at both the power plants and to work, I believe, on he was explaining to me yesterday, on airplanes. As far as the danger to the community, he has no history of violence. The one case that he had, he went into the state's program and he successfully completed it. With regards to being a flight risk, Mr. Orrego has been present in, he's lived in South Florida for most of his life. I do know that yesterday I personally surrendered Mr. Orrego to the Broward County Jail. There was Miami-Dade officers that tried to serve this not-in-custody capias at his home. His parents were there. Mr. Orrego was not present. As soon as he found out about the warrant trying to be served, he contacted our office, set up a meeting with us, and we surrendered him later that day. Again, he's not a flight risk. There's no danger to the community. I know that this is a felony, but I would respectfully ask for an ROR or, in the alternative, a very nominal bond. He promised to appear at every single court date.
How much?
So that's my argument.
How much would?
$1,000, Your Honor.
And Your Honor, and I do believe that there is some concern of flight risk just based on the allegations of the report, Your Honor, that he fled at a rate where, for safety reasons, the officer couldn't even keep pursuing him. But I was just going to be asking for a $1,500 bond. I'm not seeking a bond on the reckless driving. So if you want to ROR on that, I have no objection.
All right. So do you want the bond, or do you want? Because if I ROR him, I would be
On pretrial?
pretrial
He lives in-
standard supervision.
He lives in Miami-Dade County. That's the only issue.
Do you want the $1,000?
So the $1,000 bond would be fine.
Okay. All right. So count 1's going to be $1,000, and count 2 will be ROR.
Thank you, Your Honor.
You're welcome.
Have a great day.
You're very welcome. Take care. That's fine. All right, so now we're hopefully, done with the out of turns. We're gonna go down the docket. So we have Heather Sander.
North Broward.
All right, thank you. All right, Ms. Sander, welcome. How are you, ma'am?
Good morning, Your Honor.
Good morning, ma'am. All right, Ms. Sander, you're charged with a violation of probation on case number 1301626CF10A. You're being held no bond, but the good thing is that you're going to be going to see the division judge on January 18th, 2017 at 9:45. All right, ma'am, thank you very much. Good luck to you, okay?
Thank you for your work.
Terry Irvin.
Main jail.
All right, thank you very much, Mr. Faberg. Mr. Irvin, good morning. How are you?
Your Honor,
All right.
before we proceed, if we could just... All right, I just want to make sure the alleged victim is present.
Oh, on Mr. Irvin's case?
Yes, Your Honor.
All right. All right, Mr. Irvin, you are present. Ma'am, what is your name? Rochelle? Sutton? Okay. All right, Miss Sutton, you are present. As it relates to this case, I'm going to advise you, ma'am, anything that you say can and will be used against you. If it is inconsistent with anything that the police officer said, for example, I'm just giving you an example, then I'm going to advise you to not talk to me about the facts of the case at all until you're given an adequate opportunity to talk to someone about your possible liability that you would be exposing yourself to, okay? All right. So, Mr. Irvin, you're charged with violation of injunction, protection, domestic violence. Any probable cause argument, Mr. Afzal? No, Mr. Afzal? On Irvin, no probable cause argument? All right. I find probable cause for the charge of violation, injunction, protection, domestic violence. As far as hearing is concerned, Mr. Linder?
Your Honor, he has no criminal history. Your Honor, just based on the nature of the allegations, I do have some concern. It appears that CPIS is also involved in this matter. I'm going to be asking for a $2,500 bond and no victim contact.
The 18th at 9:45.
All right, Mr. Farberic?
Judge, I can tell the court that he's lived here all of his life, that he is single. He has 3 children that are aged 5, 3, and 1. He does currently work at Walmart. He also works at 2 other car washes, so he has 3 jobs trying to support his family. He has about $100 in the bank, so he doesn't have a lot of money. He said that he has a lot of family that lives here in the area, and I think the state already touched on the fact he has no priors. We just asked the court to take that all into consideration.
All right, Ms. Sutton, would you like to be heard on anything as far as his release is concerned? No? Okay.
We don't have 30 months.
All right, Mr. Irvin,
The 12th.
he has no priors?
No, the only thing I saw was a prior arrest for corruption by threat, and that was dropped.
All right, Mr. Irvin, during the pendency of this injunction that is in place against Ms. Sutton, Ms. Rochelle Sutton, you cannot have any contact with her because otherwise you're going to find yourself in the same situation over and over and over again. It's a first-degree misdemeanor, but they're going to start racking up. You understand that, sir?
Yes, ma'am.
Where can you stay, Mr. Irvin?
Man,
Friend or family member that stay with?
yeah, I go to the studio. Yeah, I can go to my mom's. I go to the studio. I go to a couple places. I can leave the state.
Where's your mom?
I gotta find her.
Okay. Where's the studio?
Washington Park. Sunrise in 27.
All right. I'm not getting much information. All right, so I'm going to go ahead and set the bond at $2,000 for Mr. Irvin. And I'm going to order, Mr. Irvin, in the event that you are able to post bond, that you have absolutely no contact with Ms. Rochelle Sutton. I'm going to also order that you surrender any and all weapons in your possession. And that's basically it. All right, thank you very much, sir.
Your Honor, this is Deputy Garrett, North Broward. Can I interrupt real quick?
North Broward?
Your Honor? Yes, ma'am. We have on page 9, Kimberly Gleaves. She's here now detoxing. We're going to have to send her back. I was wondering before we send her back, instead of resetting her, maybe you could see her right now out of turn?
All right, let me see. So the G? Yes.
Come on.
I never hear you.
Okay, yeah, go ahead. We'll take care of her.
All right, here she is. Thank you.
All right, how are you, Ms. Gleaves?
Thank you.
All right. Ms. Gleaves, you're being held on 3 capiases. Count 1 is a capias for 160007497MO10A. That bond was set at $500 by the division judge. You're going to go see the division judge, and then you can address it with them because I'm not going to disturb that bond. I find probable cause for that capias that was signed by the division judge. Counts 2 and 3 are capiases on case number 1600964CF10A. You're being held no bond on those cases. As it was signed by the division judge, but the good news that you're going to go see the division judge on January 18, 2017. All right, ma'am, good luck to you. Feel better.
Thank you.
Thank you, Your Honor.
You're welcome, sir. All right, Santiago Rafael. All right, Mr. Santiago, good morning, sir. You're charged with violation of an injunction, protection against domestic violence. Any probable cause argument? All right, I find probable cause for the charge. As to bond, Mr. Linder.
Your Honor, my concern is this is, he actually is,
Any mental health problems?
he's out on a $1,000 bond right now for violating the same injunction.
He has another violation of injunction pending?
Yes, he's out on a $1,000 bond on that pending charge, Your Honor. Apparently,
Against the same victim?
yes, it's the same injunction, yes, Your Honor. And there was a no contact order in that case from Judge Zakor. Your Honor, in light of that, what the court chooses to do in the pending case is obviously within the court's discretion. As far as this case, Your Honor, I'm going to be asking for a $10,000 bond, no victim contact, and a GPS monitor because it just seems that Mr. Santiago is refusing to follow court orders.
All right, I'm not going to sua sponte revoke that bond on that other case because it's not before me by way of a motion. As Mr. Fairberg, you want to be heard on this case?
Judge, I can tell the court that he's lived here for 20 years, that he's married, he has one child that's age 13. He has a very minimal amount of money in the bank. I think he only has like $20. He does have family that lives here in the area, and he indicated to me that he's never failed to appear in court prior.
All right, Mr. Santiago, once I give you the bond, I'm going to go ahead and advise you, however, instruct you that you are absolutely, and I feel that this is superfluous. I feel that I'm just talking perhaps to a wall because you've been told this in several different forms. You were told this in the injunction hearing. You were told this in your previous charge, and you're being told this today again. You cannot have any contact with Udelka Santiago. Do you understand that, sir?
Yes.
Okay, so, and it shows, if the probable cause affidavit is correct, which I have no reason to disbelieve, but it shows that that restraining order was set to expire on August 16, 2017. So, you know, I just, all right, I'm gonna set the bond at,
I wasn't trying.
don't talk about the facts of the case, sir. I'm gonna set the bond at $7,500. And in the event that you are able to be released, I'm going to set you on pretrial release with a level 2. Which is the worst, level 1 or level 2? Level 1 is worse? Okay, I'll put level 2 electronic monitoring supervision. All right? Thank you very much, sir. Good luck to you.
Outside. Downstairs.
All right, Nestine Najak.
Judge, this gentleman needs a Albanian interpreter.
Nikaj, sorry, I said Nikaj. Najak. Nikaj. All right, we need an Albanian interpreter for Mr. Nikaj. So we're gonna have.
I was gonna say.
It's gonna be reset.
Well, yeah. I mean, maybe there's a miracle they can have one today, but most likely they're gonna have to order one, especially. Is my guess.
Okay, so let's do this. Let's go ahead and roll him over to 1:30. In
Okay.
the event that we are able to find an Albanian interpreter by this afternoon, in the alternative, it's going to have to be reset. And can we order the Albanian interpreter to come tomorrow on Saturday?
She's on the phone. I imagine she's on the phone with them right now. They'll probably
find out if they can.
tell her when they would. Yeah.
You can come back at 1:30 this afternoon.
All right, so we'll reset Mr. Nikaj for 1:30.
Thank you, Judge.
Is my wife here?
Huh?
Is my wife here?
I am ready to.
Anybody on behalf of Mr. Nesty Nikaj? No? All right. No, sir. Nobody's here on your behalf. Michael Coons.
Just go right out back, right down the middle. Right down the door out there. Down the middle.
Oh, I'm going to ask the court start at 1:30. All right, Mr. Coons. Sir, you're charged with 4 counts. Count 1 is touch or strike domestic battery. Count 2 is touch or strike domestic battery. Count 3 is touch or strike domestic battery and domestic violence battery. And count 4 is a violation of an injunction protection for domestic violence. Mr. Upsall, any probable cause argument? All right, I find probable cause for count 1. I find probable cause for count 2. I find probable cause for count 3, and I find probable cause for count 4. As far as bond is concerned, Mr. Linder?
Your Honor, Mr. Coons has a very long history of alleged violence against his parents. He's actually out on bond right now for domestic violence battery, or he's out on release for domestic violence battery against Michael Coons. He was arrested for battery in 2015 against one of his parents. That was dropped. 2011, he pled out a battery against one of his parents, and again in 2011, he was arrested for battery against one of his parents, and that was dropped. Your Honor, I'm going to be asking, based on just the history of alleged violence against his parents, that he's got a pending case and violated the no contact order allegedly here with an act of violence. I'm going to be asking for $7,500 per count, pretrial release with a GPS monitor.
Mr. Farberic?
Judge, I can tell the court he's lived here all of his life. He is single. He has no children. He currently works at Publix. He has very little money in the bank. I know that he wouldn't be able to afford the amount of bond that the state has asked for. I can tell the court that he does, obviously his family lives here in the area, but that he wouldn't be able to afford a $7,500 bond on each count.
All of them? All of them? I gave them.
All right, Mr. Coons, momentarily I'm going to go ahead and set the bond on each case, but I'm going to go ahead and advise you. And again, I feel like I'm talking to a wall. Today must be a talk to a wall day because, Mr. Coons, you've already been advised in court, in the injunction hearing, you've already been advised in your previous case to stay away from your parents, Lori Coons and Michael Coons. That injunction was set to, I don't want you to speak, sir.
Your Honor, and I apologize. I'm being told Lori Coons is his sister.
His sister, all right.
You
That injunction was set to expire March 28, 2017. So you only had 1.5 more months, but it apparently is not setting in. So I'm going to set the bond on count 1 at $5,000. I'm going to set the bond at count 2 at $5,000. I'm going to set the bond at count 3 at $5,000. I'm going to set the bond at count 4 at $5,000. I'm not going to sua sponte revoke that bond on that other case because that motion is not before the court right now. And in the event that Mr. Coons is able to bond out, thank you very much, ma'am. I'm going to set him, I'm going to order that he be put on pretrial release on level 2, electronic monitoring. Thank you very much, sir.
Here. Here.
Giovanni Oldano?
He needs a Spanish interpreter.
All right, do we have a Spanish interpreter? All right, can we just put him on a brief recall? We'll get the Spanish interpreter up here as soon as possible. Thank you, Mr. Farberic.
Great, thank you.
Matthew Wood. Matthew Wood? Good morning, Mr. Wood. You're charged with battery as a domestic violence second or subsequent offense. Mr. Upsall? All right, sir. I find probable cause for that count. And Mr. Linder?
Your Honor, just one moment.
Where did he go? That house. Yeah. I need him back, my money.
Your Honor, in candor and fairness, I'm checking his record. So I'm missing something. Okay, from what I can tell, and I hate to go backwards a little, but he doesn't have a prior battery. He was arrested 2015 for domestic violence battery against a different alleged victim that was dropped. So I would ask the court to find probable cause for misdemeanor domestic violence battery.
Okay.
But additionally, in 2009 at Key West, he pled out a charge of extortion. That's the end of his record. Based on the level of violence and his alleged record, his record, I would be asking for a $2,000 bond and no victim contact.
All right, so I do find probable cause for a misdemeanor domestic violence battery charge, seeing as how he doesn't have a prior. Mr. Farberic?
I can tell the court that he's lived here for 21 years. He's married. He has 2 children that are aged 3 and 2. He has no money in the bank. He does have a job that he works as a lawn maintenance person for a golf course. He does have family members that do live in the area. We would just ask the court to set, as it's a misdemeanor, to set a reasonable bond in the case. I would ask the court to consider $1,000.
Okay. All right, Mr. Wood, I'm going to go ahead and set that bond at $1,000.
Thank you, Your Honor.
You're welcome, sir. But I'm going to also, Mr. Wood, pay close attention because apparently the two people that were here before you didn't get it. I'm going to tell you, I order you to stay away from Courtney Gannon. Okay, don't go near
Y'all
her,
have
don't
no.
contact her, don't have anybody contact her on your behalf, nothing during the pendency of
Yes,
this
Your Honor.
case. All right, and I'm going to order you also to surrender any and all weapons that you may have in your possession. All right, sir?
Yes, ma'am. Yes, Your Honor.
All right, take care, sir.
Thank you.
Daniel Angren?
So gonna be a medical reset, Judge.
I believe he's on medical loan.
Okay, so he's on he's a medical reset to tomorrow. Adam Noble.
Yes, Your Honor.
All right, Mr. Noble, welcome, sir. Good morning. You're being held on an out-of-state hold for a felony case, and you're being held no bond, so hopefully they'll come get you as soon as possible, okay?
Yes, ma'am. Thank you, Your Honor.
You're very welcome.
All right.
Take care, sir. I find probable cause for that out-of-state hold, and the bond is... Simon Williams?
Williams? Come on up. Are you Simon Williams?
Simon Williams?
One second, Judge,
Sorry,
check in. Main jail.
Okay. Miss Williams, welcome. I called you. I'm sorry I called you Simon earlier. Miss Williams, you're charged with possession of cannabis 20 grams or less. That's a first-degree misdemeanor. Mr. Afzal, any probable cause argument?
Anthony Thomas.
All right, I find probable cause for the charge. As far as bond, right now it's set at $100 convenience bond. I have no... Mr. Linder?
No, I'm not seeking any modification.
All right, Mr. Fabarek, you want to be heard on the $100 bond?
Judge, she indicated to me, I don't know if the court's in a position that we can work it out today. She would be willing to do that. I would just ask the court if the court would withhold an adjudication and give her court costs.
Mr. Linder?
I'd have no objection to that.
All right, Miss Williams, would you please raise your right hand? All right, Miss Williams, do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, you may put your hand down, ma'am. Are you under the influence of any alcohol, medication, or drugs?
No.
Have you ever been treated for a mental illness?
No.
Can you read, write, and understand English, ma'am?
Yes.
All right, ma'am, and your attorney, Mr. Fabarek, from the Public Defender's Office, has informed me that you want to go ahead and resolve your case to a withhold of adjudication and court costs this morning?
Yes.
All right, you've had enough time to talk to Mr. Fabarek?
No.
If I can have 1 second, Judge?
Sure.
Okay, Judge.
All right. So now, Ms. Williams, same question. You've had enough time to talk to Mr. Fabarek?
Yes.
All right, very good. You satisfied with his services, ma'am? You satisfied with his representation? Yes. Okay, he's good, right? He's getting you a withhold and court costs on this. All right, good. All right, Ms. Williams, and you don't want to take this case to trial, is that right?
She said that.
You don't want to fight it, right?
No.
All right. Are you on probation or parole anywhere in the world?
No.
All right. Ma'am, and you understand that if you're not a U.S. citizen, this will subject you to deportation. You understand that?
Yes.
All right. Ms. Williams, as to the charge of possession of cannabis 20 grams or less, how do you plead guilty or no contest?
No contact.
All right. Accept your plea, offend that you're freely, voluntarily, intelligently waive your right to offend that you're competent, coherent, alert, confirm that you're normally entering this plea, and understand the nature of the charges, the consequence of the plea. Counsel, you stipulate to a factual basis? All right. For
We would,
purposes of
Judge.
the plea, upon the stipulation, I find that there's sufficient factual basis and sentence you according to that negotiated offer with the court of a withhold of adjudication court costs. I'll give you 6 months to pay those court costs, Ms. Williams. All right. Good luck to you, ma'am.
Okay.
Good luck to you.
Brooke Price.
North Broward.
All right.
Go right here. Stand at the podium. You're good to go.
All right, Ms. Bryce, how are you doing today?
I'm okay, and you?
I'm doing very well. Thank you for asking. All right, Ms. Price, you're being held on a capias on a misdemeanor 16008998 MM10A. I find probable cause for that capias, seeing as that it was signed by that other judge, and that judge set the bond at $1,000. I'm not going to disturb that bond. However, the good thing is that you're going to go see that judge on January 23rd, 2017, at 1:30 p.m. All right, ma'am. All right. Good luck to you, ma'am. Take care.
You too.
Sade Boss. All right, North Broward. All right, Ms. Boss, how are you?
Hello, how are you?
I'm doing well, thank you for asking. Ms. Bass, you're being held on a violation of probation on a misdemeanor case 1600028 MM38. That bond was set by the division judge for no bond, so I can't disturb that bond. I find probable cause for that violation of probation, and you'll hopefully be seeing an attorney as soon as possible, a judge as soon as possible, okay? Okay, take care, Ms. Bass. Do we have the Spanish interpreter? All right, very good. We're gonna go back to the main jail. Mr. Ferrer, we have the Spanish interpreter for Mr. Giovanni Oldano. All right. Mr. Interpreter, would you please raise your right hand, sir? Do you swear or affirm that the interpretation you do from Spanish to English and from English to Spanish shall be the best and true, accurate to your ability? All right, very good. So, Mr. Oldano, you're being charged with 3 counts.
A usted se le acusa de 3 cargos.
Count 1 is touch or strike, domestic violence battery.
El primero es tocar o golpear, en otras palabras, agresión por violencia doméstica.
Count 2 is touch or strike, domestic battery.
El segundo es tocar o golpear, agresión por lesiones domésticas.
And count 3 is touch or strike, domestic battery.
Y el tercer cargo es tocar o golpear de forma que es agresión con violencia doméstica.
Mr. Absol, do you have a probable cause argument?
¿Existe causa probable?
I find probable cause for count 1, count 2, and count 3.
Considero que para los 3 cargos existe causa probable.
Right, and as far as bond is concerned, Mr.
Se refiere a la fianza.
Your Honor, Mr. Aldano has no record. I'm going to be requesting a $1,500 bond per count and no victim contact.
Su señoría, el señor Roldano no tiene ningún antecedente penal. Voy a solicitar una fianza de $1,500 per count.
Yes.
$1,500 para cada cargo y que le quede prohibido el contacto con la víctima.
Con las víctimas, well, with the victims.
Con las víctimas.
Pero,
Okay, Mr. But hold on, Mr. Oldano, I don't want you to talk to me about the facts of the case because this is a non-adversarial hearing.
Señor Oldano, este no es un procedimiento contencioso, por lo cual solicito que no se refiera a los hechos del caso.
So momentarily, I'm going to go ahead and set a bond on each count.
De momento, lo que voy a hacer es fijar su fianza para cada cargo.
But in the meantime, I want to go ahead and advise you and order you, sir.
Pero mientras tanto, le voy a sugerir, a recomendar, señor, y ordenar
That you are to have absolutely no contact with the 3 victims in this case.
que no tenga contacto alguno con ninguna de las 3 víctimas en este caso.
That is to include Reina Beatriz Santanilla,
Lo anterior incluye a Laina Beatriz Santanilla,
Valentina Oldano,
Valentina Roldano
and Diego Cano.
y Diego Cano.
Those are the 3 victims that you are to have absolutely no contact with.
Esas son las 3 víctimas con las cuales le queda prohibido tener contacto.
Now,
Ahora,
if you're able to post bond, Mr. Oldano, where are you going to live? Because you cannot go back to this house where you all live together.
señor Oldano, si usted logra pagar su fianza, ¿a dónde piensa vivir? Porque usted no puede regresar a este domicilio donde usted vive con las 3 víctimas.
pero es que esa es mi casa.
But that's my house.
And I understand that, sir, but I'm ordering you, because of this case, during the pendency of this case, you cannot go back to that house.
Entiendo, señor,
No,
pero
pero-
mientras se encuentre pendiente este proceso judicial, usted
Ajá.
estará bajo órdenes de no regresar a esa casa.
So where are you going to go?
Así que, ¿a dónde va a ir?
Pues tendré que ir donde mi cuñada, donde mi hijo.
Well, I'll have to go to my sister-in-law's house or to my son's.
Okay, what address is that?
¿Cuál es la dirección de ese lugar?
No la tengo en este momento.
I don't have it on hand.
Es que para mí es toda una sorpresa.
To me, this is a surprise.
Okay, and I don't want you to talk to me about the facts of the case because you're not supposed to,
No quiero que se refiera a los hechos de este caso porque usted no puede.
Anything you say can and will be used against you in this case.
Cualquier cosa que usted diga puede y será utilizado en su contra.
Mr. Fairbank, did you have an opportunity to speak to him at all?
Señor Fabric, usted...
Judge, I wasn't able to speak to him, but I would, if the court wishes to inquire with regards to his financial abilities to post bond, I would ask that on his behalf, based on a number of factors. What I would be asking the court, I know that they indicated, the state indicated there's no priors. I would ask the court if the court would consider RORing him to pretrial release. They can do that by verifying his address. So once they verify the address, he could be released ROR.
Su señoría, no he tenido la oportunidad de hablar con el acusado. Sin embargo, no tendría ninguna objeción si la Corte desea preguntarle con respecto a su situación financiera. Dado el hecho de que no tiene antecedentes, solicitaría que fuera liberado bajo palabra. Puede ser puesto en libertad de manera preliminar al juicio. Eso se puede hacer si se le verifica su dirección.
Judge, I can just tell the court, I know he's in his later 60s, and also I've noticed that just kind of getting around the jail, he's just, when he got up, he kind of stumbled a little bit, so, there may be some issues with regards to age-related issues.
También quisiera informarle a la Corte que el caballero tiene casi 70 años y lo observé cuando se levantó para venir al estrado y tuvo alguna dificultad y tiene cierta dificultad para movilizarse, así que podría haber algunos asuntos relativos a su edad que pudieran complicar su estadía en la cárcel.
All right, Mr. Oldano, the state is asking for a bond of $1,500 on each count for a total of $4,500.
Señor Roldano, la Fiscalía está solicitando una fianza de $1,500 para cada cargo, lo que daría como total $4,500 de cargo de fianza para los 3 cargos.
All right, do you have that money?
¿Tiene usted ese dinero?
Sí, sí lo tengo.
Yes, I do.
Oh. All right, so I'll set the bond at $1,000 on each count.
Bien, entonces voy a fijar la fianza en $1,000 para cada cargo.
Mr. Oldano, but I'm going to tell you, please do not have any contact with these 3 victims. I understand that they're your wife, your daughter, and I believe your son or your daughter's wife. Your son, I don't understand. Regardless, you cannot, during the pendency of this hearing, have any contact with them. Understood?
Señor Roldano,
Yes.
Sin embargo, debo informarle de manera muy enfática, pese al hecho de que las víctimas sé que son su esposa, su hija y creo que su yerno, aún así, usted no puede mantener contacto alguno con estas víctimas mientras se encuentre todavía pendiente este caso.
Okay?
¿Está bien?
Okay.
All right, very good. Thank you very much, sir.
Gracias.
Thank you, Judge.
All right, sir, interpreter, would you like to make an announcement at the main jail?
¿Hay alguna otra persona presente que necesite interpretación al español?
All right, anybody in the main jail need the assistance of the Spanish interpreter? Please stand up or come up to the podium. No?
I don't believe so, Judge.
All right, let me do that if you would be so kind and indulge me, Mr. Interpreter. At North Broward, does anybody need the assistance of the Spanish interpreter?
Nobody needs Spanish. No, we're good over here, Your Honor. Thank you for asking.
All right, very good. Let's go to Conti.
No, ma'am.
All right, very good. Look, you read my mind. That's good. That's awesome. All right, Paul Rain. Anybody need the assistance of? Okay, perfect. Very good. Thank you very much, sir.
Sure.
All right, we're back at the main jail. Evelyn Avant.
North Broward.
All right. How are you, Miss Avant?
I'm fine. Good morning.
Good morning. Miss Avant, you're being charged with 2 counts. Count 1 is burglary of an occupied structure unarmed. And count 2 is grand theft auto, and that is by way of a not in custody capias. So I find probable cause for those capiases that were signed by that judge as far as bond is concerned. Mr. Linder.
Your Honor, I don't see a criminal record. However, count 1 is a second-degree felony. I'm going to be asking a $3,500 bond on 1. I'm not seeking any modification on count 2, and no return to the incident location.
She has no priors?
Judge,
No,
he has,
Judge.
I can tell you that she is employed in Broward County. She works at the airport. She was a supervisor at the Starbucks. She was there for 7 months. She's a graduate of our Northwestern High School in Miami, currently living in Miami Gardens. She lives there with her mom. She has about $500 in savings. She makes payments on a car, $300 a month. I would ask, according to life, the fact she has no priors, set $2,500 bond on count one.
All right. Count 1 will be set at $2,500 and count 2 will be set at $1,000. Thank you very much, Ms. Avant. Take care.
Your Honor, I'd ask for no return to that business.
Yes, that is with
Oh.
no return to that business, ma'am.
Thank you.
Okay, you understand that? You cannot go back to that business.
Yes, ma'am. Thank you.
All right, you're very welcome. Take care. Maria Drobezeva.
Main jail. Judge, she indicated she's going to hire private counsel.
All right. Welcome, Ms. Drobezeva. How are you?
I'm good, thank you.
All right. Ms. Drobezeva, have you retained an attorney?
No.
Are you?
Not yet, I believe so.
Okay. So at this time, do you want to proceed with this magistrate hearing without an attorney present?
No, believe, I believe I will we hired the public defender.
Okay, you want to get the public defender?
I guess so.
I'm here.
All right. I provisionally appoint the public defender, Mr. Fairberg. You see how quick that service is? It's like that. All right. Ms. Drobezeva, you're charged with trafficking methamphetamine, 14 grams, less than 28 grams. Any probable cause argument? All right, I find probable cause for that count. And as far as the bond, Mr. Linder?
Your Honor, in 2012, she went through drug court for possession of methamphetamine, possession of another controlled substance felony level drug paraphernalia. She did complete drug court. The charges were dismissed. However, that being said, I am going to be asking for that the $50,000 bond be kept in place, even with no criminal history. If convicted of this offense, she faces a minimum mandatory prison sentence. Your Honor, it appears, based on these allegations, she was bringing a trafficking amount of drugs into the state from a flight. And Your Honor, and I'm sure the court's going to inquire or will be informed, but I don't know at this point what her ties to the community are.
All right, Mr. Fairberg?
Judge, I can tell the court that she's lived here for 9 years. She's divorced. She has no money in the bank. She works. She's self-employed as an artist. That she indicated she does have family members here. I don't believe she'd be able to post a $50,000 bond. We would ask the court to set something less than that.
What?
Judge, I would ask for a in the neighborhood of 15 to 20,000.
And Your Honor, I would just note that whether it's her money or someone else's, it appears she has access to some type of finances. She was arrested coming off a flight and found to be in possession of 20 grams of methamphetamine. These aren't items that are available for free.
Excuse me.
Cameras don't reach up there.
Oh, and I apologize, Your Honor. In addition to any bond the court sets, we would be asking for a passport surrender.
She did drug court, you said, back in 2011?
Yes.
And she was successful?
She was. I was obviously on just a simple possession. I'm checking, Your Honor. Yes, in this matter, if convicted, she faces a 3-year minimum mandatory prison sentence and a $50,000 fine.
Okay. All right, so I'm going to order Ms. Drobezeva to surrender her passport as part of the condition of her release. And I'll set the bond at $30,000. And that's it.
Your Honor, we just asked that the passport be surrendered to the clerk's office prior to her release.
I know, that's gonna be a little tricky.
Your Honor.
But you know what? Here's what I'm gonna do.
Do that all. I'm so.
Do, and I contemplated it. I'm gonna go ahead and I'm gonna set her on pretrial release as well for a standard supervision, and I'm gonna order that she surrender her passport to pretrial release.
They can't take.
Okay, so I'm gonna order her to surrender the passport within a week of her release to the clerk's office, and then can you verify that she did?
Judge,
What's in the behalf? We have clients who are in custody, and a family member goes and they bring the receipt.
Gotcha.
Your Honor, we're going to ask for 48. State's going to ask for 48 hours. The concern, the reason for asking for a passport surrender is concerns that she may flee the jurisdiction. Giving her a week to keep her passport in her possession really defeats the intent.
That makes. All right, so 48 hours. Did you want to say
Judge,
something, Mr.
I do. With regards to the passport, she indicated that she doesn't have a passport at this time. She came into the country 9 years ago.
Oh.
And she said she doesn't have a passport.
Then, Your Honor, what I would ask is if you could put her under oath. This is customary. If you could put her under oath, and she could testify that she's not in possession of a passport, since at this point, the court would.
If I can just.
Yes, go ahead, Doctor.
If I can just clarify it, Judge, she has one, but it's already expired. It's not valid. She would have to get another one if she wanted to travel anywhere.
Well, we still would ask we'd ask that passport be surrendered, with an additional order that she not reapply for a passport, because she could use that expired one to apply for a new one.
Okay. So I'm going to give her 48 hours to surrender her expired passport.
So as soon as you get out, get there and give it to her. Okay.
To clerk of court, yes.
Okay, you have to bring it back down here to the clerk of court and surrender it, okay? When you get out, you got to post the bond and that, but as soon as you get out, see pre-trial, go get the passport and bring it right back.
Thank you.
Thank you, Judge.
You're welcome.
Okay. Good.
Stacy Bustillo. Welcome, Ms. Bustillo. You are charged with 2 counts of good morning. 2 counts of violation of probation. Count 1 is on 140-11614 CF10A. You're being held no bond on that. I find probable cause for that VOP warrant, and that no bond was set by the division judge. Count 2 is a violation of probation on case number 150055564 CF10A. You're being held no bond on that as well, so that's not being disturbed. The good thing is that you're going to go see your division judge on January 18, 2017 at 9 a.m. All right, ma'am, good luck to you.
Thank you.
You're welcome. Priscilla Detris?
Judge, she's over at the North Broward Jail.
All right. Ms. Detris?
Hello.
Welcome, Ms. Detris. How are you?
I'm good. How are you?
I'm doing well. Ms. Detris, you're charged with grand theft. That was a non-in-custody capias. The probable cause was found by the division judge. Signed by it, Judge Haynes. So I find probable cause for that grand theft. And the bond right now, Mr. Linder?
Your Honor, I'm just asking that the $1,000 bond be kept in place.
No objection.
All right. And the bond is set at $1,000. Ms. Detris, thank you very much. Good luck to you. Take care.
Thank you.
You're welcome. Larika Rawls?
Paul Ryan?
Ms. Rawls.
All right, Ms. Rawls, how are you doing today?
Okay, and you?
I'm doing well, thank you for asking. Ms. Rawls, you're being charged with grand theft. Between $300 and $5,000. That's a third-degree felony. Any probable cause argument? All right. I find probable cause for that charge, Ms. Rawls. And the bond right now is, the convenience bond is $1,000. Mr. Linder?
I'm not seeking any modification, Judge.
All right, anything, Mr.? Sure.
Ma'am, can you afford $1,000 bond?
Hopefully, I'm not sure, because I don't have no money. My mom says she's gonna try. And I have a son that's only 1 year old. I need to get home to.
And she has multiple thefts priors out of Broward. That's why I would oppose a reduction, but I wasn't asking for an
All
increase.
right, I'll leave it at $1,000. Thank you, Ms. Rawls. Claude Smith.
North Broward.
Oh, all right, Mr. Smith.
Well, Smith.
Is that you, Mr. Smith?
No, hold on, you come out.
No.
I got you. Where's Smith? Come on.
Oh, Miss Smith.
Right here, man. Right here. Yeah, yeah.
I apologize.
That's okay.
All right, Miss Smith, good morning. You are being charged with possession of heroin. Mr. Afzal?
I have no probable cause argument, but I can tell you, Judge, that she's a resident here on and off since 1988. She was living in California for 7 years, but the last 10 years she's been staying in Hollywood. She resides with her nephew and his girlfriend. She works part-time at MD caulking and waterproofing. She's struggling a little bit now. She doesn't have enough money to post bond, hasn't been able to contact her nephew to bond her out. I would ask the court to place her on pretrial release pending verification.
All right, I find probable cause for the charge of possession of heroin. Mr. Linder?
I'm fine with the release to pretrial if they're able to verify her.
All right. Any priors?
No, Judge.
All right. So I'll put her, put her on pretrial. Miss Smith,
I'm listening.
where do you live?
Right now?
Yes.
Yes. At that address?
What address is that?
6458 Evans Street.
Okay, that's not the
57.
address. All right, that's not the address that is on the arrest report, but
And that's because I was there at the time. I was there visiting at the time on the arrest report.
okay.
Maybe that's on Johnson Street?
All right, but if you're not able to verify, then I have to give her a monetary bond, right?
Well, if the court is going to release her pending verification, the bond will remain. And only when we are able to verify her, then she would become ROI and released to pretrial.
Okay. All right, so I'm going to leave the bond at $1,000, but I'm going to ROR you provided that pretrial release is able to verify your address. Okay, Miss Smith?
Okay. Pending verification and not ROI.
So I put 1,000 or ROR to PTR to pretrial release upon verification. Well, I already did. You want to scratch it off? All right, thank you very much, Miss Smith.
Thank you.
Melissa, you're welcome. Melissa Steinquist? Steinquist? You were already here. All right, Ms. Stenquist, welcome. You're charged with count 1 is burglary of an occupied dwelling unarmed. Count 2 is grand theft between $1,000 and between $10,000 and $20,000. And count 3 is grand theft auto. Mr. Oswald, do you have any probable cause?
I don't, Judge.
All right, I find probable cause for count 1, I find probable cause for count 2, and I find probable cause for count 3. As far as the bond is concerned, Mr. Linder?
Your Honor, I am a bit concerned. Ms. Stenquist pled out of possession of cocaine October 20th of last year and a grand theft on a separate case on a VOP and was sentenced to 364 days. She was just released from custody December 23rd of last year. She also had a violation of probation, possession of cocaine 2010, trafficking in hydrocodone, possession of oxycodone, clonazepam, and a grand theft in 08 and a theft in 08. Your Honor, based on the value of the property that was stolen, count 1 being a second-degree felony and allegedly the home was occupied, I am going to be asking for a $20,000 bond on 1. No victim contact should she post her bond, pretrial release with a GPS monitor.
Judge, a $20,000 bond is tantamount to no bond for her. There's not much she can afford at this juncture.
She was just released from jail.
I understand, but she is charged with a third-degree felony.
Second.
Oh, I apologize, second-degree felony. I mean,
and Your Honor,
I'm just saying that $20,000 is a bit on the high end for her.
and I would just say, Your Honor, while $20,000 may be more than she would tell the court she has access to at this moment, under the circumstances, I don't believe it's tantamount to no bond.
Judge, I believe the sentence that she served was for possession of cocaine, not a similar related offense. Am I
And a grand
correct?
theft.
It was a possession of
She
cocaine?
had a VOP and a grand theft also that she got 364 days.
Judge, I can tell you her ties are that she lives in Fort Lauderdale with her mom, who's currently disabled. She's not working. She did go to school down here, owns no property, resident here all her life. I mean, even if you set a fine, she's not going to be able to afford it.
All right, count one will be set at $10,000. Count two will be left at $1,000, and count three will be left at $1,000. I'm gonna also order that she be put on pretrial release with level 2 electronic monitoring to ensure that she stays put. Thank you, Ms. Stenquist.
And Your Honor, we'd ask for no victim contact, please.
And no victim contact, Ms. Stenquist.
Thank you.
Thank you. Latasha Davis?
There you go.
How are you, Ms. Davis?
Good morning, and yourself?
I'm doing well, thank you for asking. Ms. Davis, you're being held on 4 counts. Count 1 is a capias for case number 1501427 CF10A. That bond was set as no bond by the division judge. I can't disturb that. I find probable cause for the capias. Count 2 is a capias for 150051441 CF10A. I find probable cause for that capias by the division judge. It was found probable cause originally, and the division judge set it at no bond. I'm not disturbing that bond either. Count 3 is a violation of probation on case number 150051441 CF10A. That's a no bond as well. I find probable cause for the violation of probation warrant. And count 4 is a violation of probation warrant on 1501427 CF10A. You're being held no bond on that. The good thing is that you're going to go see your division judge on January 18, 2017. All right, ma'am? Thank you.
Okay.
Shamika Todd?
Main jail.
All right, Ms. Todd, how are you doing today?
I'm good.
All right. The what?
Second page, teletype confirmed out of Boynton Beach. Second page.
Teletype confirmed that the vehicle was entered as stolen out of Boynton Beach. Any other argument? All right, I find probable cause for the charge of grand theft auto. As far as the bond is concerned, Mr. Linder?
Your Honor, she had, as a juvenile, she had related offenses. I'm just asking that the convenience bonds be kept in place.
All right, Mr. Faber?
Judge, I can tell the court that she's lived here all of her life. She has 2 children that are aged 1 and 2. She has no money in the bank. She's currently not working. She does live with her grandmother. She indicated to me that she's never failed to appear in court before. She also indicated that she's trying to go back to school at this point. And I think I said she does live with her grandmother. I would ask the court to leave the bond on count 1 at $1,000 and also to leave counts 2 and 3 as no charge.
Yep. That's good, that's what we'll do. Thank you. Edward Christie.
Judge, this is a municipal ordinance case. I don't know if anybody's here from the city, but we would ask the court to. We don't represent them, as the court knows. We don't represent them on municipal ordinance cases. I don't know if there's an attorney present in the courtroom either to represent them. We would ask the court to basically to dismiss the charges because there's nobody there to prosecute. But if the court's not inclined to do that, we would ask to be ROR'd.
What is Mr. Christie? This is an ad charge on a capias, a misdemeanor case. What are the other 2 cases?
One moment, Your Honor. I believe, is this a municipal ordinance?
Yes, this is
Okay.
municipal ordinance.
Checking that right now.
Thank you.
Okay, Mr. Christie was arrested on December 30th. Your Honor, disorderly conduct and corruption by threat. He's got a $25,000 bond on the corruption by threat.
All right, Mr. Christie, I find probable cause for the capias. I'm seeing it was signed by the judge.
Ma'am,
And no, Mr. Christie, don't talk to me about the facts of the case. Do you have other charges that
it's
are
not about the
holding you?
case. He's telling me it was a capias for. I was supposed to be in court January 5th for an open container in Hillsborough.
Correct.
That's what he said. That's what he said. This is all about was
Correct.
Because I missed court
Correct.
January 5th.
Right. Okay. All right, so we're on the same page. So this is a capias on that misdemeanor. The bond by that judge was set at $100. I'm not disturbing that bond, sir. You're gonna go see, when you take care of your other cases, you're gonna go ahead and see the other judge as well. All right, take care.
Was
sir.
he in custody at the time of the arrest? I think he was.
Yes, I was.
I think he was in custody at the time. So
That's
if
what
he's
I'm
missing
trying
a
to
date
say.
while he's in custody, he wouldn't.
He missed court on January 5th, so there was a capias issue
No,
for his
but
arrest, but he was
he's-
already arrested.
He was already in custody.
Right, he was already in custody.
So the date he missed, they didn't take him over to
Right,
the.
because
Will
they
the court
didn't have- they
ROR
didn't have a
him on that count if he's in custody?
He's not going anywhere. He's $25,000.
I understand, but he's not. He doesn't have the benefit of having an attorney.
And I'd really like to have
Nobody's
the, and I'd really like to have the capias taken off my record for future.
Well, you can address. Oh, this is a municipal ordinance.
They're not going to take him to Hillsborough, Judge.
No, I know they're not going to take him to Hillsborough. They're going to go.
And I have a trespassing charge. And I have a trespassing
You can
charge.
resolve this case if you want to. It's an open container, Judge.
All right, let me see Mr. Smith's case.
And I'd also like to note that I have a trespassing charge in Hillsborough on January 28th, so we don't have this problem again. Because I have another charge, a trespass charge, in Hillsborough, January 28th. So could you let them know I'm here for that one? So I'm just trying to clear up the open container. It's only an open container. I'd really like to have the capias taken off my record because I've never missed court.
Well, I don't think your missing court was intentional, seeing as how you were in custody at the time. So I don't know if I have a mechanism to do that.
The only thing, Your Honor, which I would, and this is a friend of the court.
Right.
The court can ROR if you choose or plead out whatever he wants. If Mr. Christian wants an ROR, the only thing I would ask you to advise him is that he won't get game time on that count.
Right. That's a municipal ordinance.
I know. I'm just saying. I just want him to be know all his options. That's all.
All right, Mr. Christie, you want to resolve this case? You want to resolve this municipal ordinance case to a withhold of adjudication and court costs?
Yes, ma'am, I would.
All right. Would you please raise your right hand, sir? Do you swear affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
All right, you may put your hand down. Mr. Christie, are you under the influence of any alcohol, medication, or drugs?
No, ma'am.
Have you ever been treated for mental illness?
No, ma'am.
Can you read, write, and understand English?
Yes, I can.
All right, so you understand everything that's going on here today?
Yes, I do.
All right, Mr. Christie, you're charged with open container of an alcohol beverage, and you wish to resolve your case at this time to a withhold of adjudication and court costs?
Please.
All right, and you don't want to take this to trial, sir?
I'm sorry?
You don't want to take this case to trial?
No, I just want to get rid of it and let
Okay.
Hillsborough know that I'm here for January 28th.
Okay, hold on. Look, one thing at a time.
Okay.
Mr. Christie, you understand that if you're not a U.S. citizen, this will subject you to deportation. You understand that?
Yes, I do.
All right, and are you on probation or parole anywhere in the world?
Nope.
All right, very good. Mr. Christie, as to the charge of open container, how do you plead guilty or no contest?
No contest.
All right, accept your plea. I find that you're fully voluntarily intelligent, waiving your right to find that you're competent, coherent, alert, and I find that you're no entering this plea and understand the nature of the charges and consequences of the plea. After reviewing the charging document, I find that there's sufficient facts to be fair plea and sentence you according to the negotiated offer for withhold of adjudication and court costs, the negotiated offer with the court. Now, as far as the other case, Mr. Christie, I
just want him to know that I'm here so we don't have to do this again.
It's a trespass?
It's a trespass from December 28th, and he just wrote me a court appearance.
All right, Mr. Christie, hold on 1 second. Okay, that was no info.
that was no info?
Yes.
Okay, so the charge was dropped, so you're not gonna have to go to court on that date, okay?
Thank you very much.
You're very welcome, Mr. Christie. Take care.
Have a nice day.
You too. You're all Skaggs. All right, Mr. Skaggs, good morning. Count one. You have a capias on a traffic case 120-15623-TC30A. That bond was set. I find probable cause for that capias, seeing as how that division judge signed it, and that bond was set at $500, which I'm not going to disturb. And count two. You have an out-of-county hold that you're being held no bond on. Count three is an out-of-county hold that you're being held no bond on, and count four is an out-of-county hold that you're being held on a $10,000 bond. Those charges are not for magistrate. All right, sir, as soon as you can get in front of a judge to deal with that capias case, and I guess they'll come get you.
You have children?
All right. No, it's Palm Beach. It doesn't have that far. Athea Mulner?
Were you injured when you were arrested?
All right, Mr. Mulner, you're charged with a violation of probation in case number 150198886 MU10A. The bond by the division judge was set at $2,500. You should be seeing your division judge soon enough. I find probable cause for that VOP. Thank you very much, sir. Take care. Timothy Mejias.
Yes, ma'am.
Mr. Mejias, you're being held on a capias on case number 1600867 MM10A. I find probable cause for that capias, seeing as how the division judge signed it. I also cannot disturb the bond that was set for $1,500 on that case. The good thing is that you're going to go see that division judge on January 23rd, 2017. Good luck to you, Mr. Mejias. David Cornelius. Mr. Cornelius, you're being held on a capias on 1603467 TC30A. I find probable cause for that capias, seeing as how the division judge signed it, and that bond on that capias was set at $250. Hopefully, it'll get you in front of the
Judge, he wanted to know if the court's in a position to resolve this today.
Hold on a second.
State any input?
I'm looking into the case right now. Yeah. I see a prior from 2015. State's offered being adjudication time served. With the understanding that if he picked up another one, he probably wouldn't be getting an offered first appearance from the state.
All right, that's the state's offer. Mr. Fairbarrick, you want to open plea, or you want to take that up?
Judge, I just spoke to him. He wishes to accept that offer.
Oh. All right, Mr. Cornelius, would you please raise your right hand? Please swear affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may put your hand down, sir. Are you under the influence of any alcohol, medication, or drugs?
No, ma'am.
And have you ever been treated for mental illness, sir?
No, ma'am.
And can you read, write, and understand English?
Yes, ma'am.
All right, Mr. Cornelius, at this time, you wish to take the state's offer, which is an adjudication of guilt that would be a conviction on your record, court costs, and time served. Is that right, sir?
Yes, ma'am.
All right, you've had an opportunity to speak to Mr. Fairbarrick about this offer?
Yes, ma'am.
And you're satisfied with his services, sir?
Yes, ma'am.
All right. Mr. Cornelius, you don't want to take it to trial either?
No, ma'am.
All right, you understand that if you're not a U.S. citizen, this will subject you to deportation?
Yes, I do.
Okay, and are you on probation or parole anywhere in the world?
No, ma'am.
All right, Mr. Cornelius, as to the charge of operating without a valid driver's license, how do you plead, guilty or no contest?
No content.
All right, accept your plea, I find that you're freely, voluntarily, and intelligently waive your right to defend that you're competent, criminal learner, defend that you're criminal entry, this plea, and understand the nature of the charges and the consequence of the plea. Mr. Fairbarrick?
Judge, we'd stipulate for purposes of the plea.
All right, for purposes of the plea, upon stipulation, I sentence you to that negotiated offer of an adjudication of guilt, court costs, and time served. I'm going to give you 6 months to pay those court costs, sir. Good luck to you, Mr. Cornelius.
Thank you, ma'am.
You're welcome, sir. David Johnson. Mr. Johnson, you're being held on a capias for misdemeanor case number 160037772 MM40A. I find that there's sufficient factual basis for that capias, seeing as how Judge, issued that capias, and the bond is set at $2,500. You're going to go see Judge Zeller on January 18, 2017.
Judge, two things. Number one, he wanted to know if the court would be in a position to work it out today.
I think this isn't drug court, it's ZD.
It is.
Yep.
The bond that I show on my thing is $2,000, not $2,500.
Yes, you're right, it's $2,000.
Thank you, Judge.
All right, very welcome. Good luck,
Wish it
Mr.
won't work it out
Johnson.
today. You have to go back to court.
David Pardue?
So I have to stay in jail until I go to court?
Judge, he needs a Creole interpreter.
All right, let's get the Creole interpreter, please, for Mr. Pardue. We're going to go ahead and set it on a brief phone call.
Yeah, just have a seat.
Patrick Jonathan?
When is she going to retire? She retired in this couple of months.
He bonded.
Oh, very good. All right. find probable cause for those charges. Ovens Jean? Mr. Jean? All right, Mr. Jean, you're charged with trespass of an unoccupied structure, conveyance, any probable cause argument. All right, I find probable cause for that charge. As to bond, Mr. Linder?
Your Honor, he has no record. I'm not seeking any kind of modification.
He has no record, Mr. Fairberg.
Judge, would the court consider withholding time served? He said he wished to resolve it today.
State, any objection?
No.
All right.
Yesterday.
Sirs, raise your right hand, sir.
Judge, if I can have just 1 second to speak to him.
Sure.
Okay. Judge, I apologize. He said he speaks English, but I believe he speaks Creole. He indicated that I do have someone here that works for our office that does speak Creole. He actually indicates now that he wants to go to court with it. So I would ask the court to consider RORing him on this charge since he has no priors, and it's a misdemeanor charge.
All right, that'll be an ROR.
Thank you, Judge.
Thank you very much, sir. Good luck.
Okay, right, you'll get out.
Justin
You have to come back to
Smith.
court. He bonded.
All right. Michael Jones.
I saw him back here too.
All right, Mr. Jones, you're being held on 5 counts. Count 1 is possession of cannabis 20 grams or less. Any probable cause argument as to that?
No.
All right, I find probable cause as to count 1. Count 2 is a capias on a misdemeanor 16001253 MM10A. The bond is set at $500 by the division judge. I find probable cause for that capias. Count 3 is a capias for the same case. That bond is set at $500. I find probable cause for that capias, and I'm not going to disturb that bond on $500. Count 4 is a capias on case number 150-11566 MM10A. That bond is set at $5,000 by the division judge. I find probable cause for that capias. And count 5 is a capias on the same case. I find probable cause on that capias, and that bond is set at $2,500, which I'm not disturbing. As to the bond on count 1, Mr. Linder.
Your Honor, asking just that the bond on count 1 be kept in place. Additionally, Your Honor, count 2, the battery, that's out of DV court. It's from an unserved summons, so this is the first time he's appearing before a judge. I would just ask if a no contact order could be issued, and I have the name of the alleged victim here.
Okay. So on count 2, I'm going to order you, Mr. Jones, to have no contact. You're going to go see your division. Oh, no. The misdemeanor violence is going to be set in division. The MA, you're going to go see the other cases. You're going to go see a judge on January 19, 2017 at 10 a.m. What's the name of the victim, Mr. Linder?
I just handed the post.
And I'm going to order you that on case number 16001253 MM10A, in addition to the bonds that were set by the division judge, that you have absolutely no contact victim with Ms. Teresa Rogers, and that you order any and all, that you surrender any and all weapons that you may have in your possession. All right? Thank you very much.
Thank you, Judge.
You're welcome. And the bond is set at $100 on count 1. Thomas Highland. Mr. Highland, welcome. How are you?
Reasonably good, Your Honor.
Good to hear. Mr. Highland, you're being held on a capias on case number 160027767 MM28. The bond, if I probable cause for that capias, and the bond that was set by that division judge was $500.
That's it. Next.
That's it?
Unless there's anything else from you, Mr. Fairberg?
Judge, he actually declined, sir, that's okay. He actually declined the PD. I don't know if it's possible to resolve it today. There you go. He just asked me if the court could resolve it, so.
Is a resolution possible? Mr. Highland?
Come again?
You want to take care of this case, Mr. Highland?
I would like to very much, Your Honor.
All right, Mr. Fairberry. Mr. Linder, sorry.
One moment, Your Honor. I just need to see what the allegations were.
You're right here. Here.
Hardly.
Okay. Your Honor, it appears this would be Mr. Highland's third trespass since last year. State's offered be adjudication 3 days. County jail.
Sorry?
Yeah.
Anything pending?
The state's offer is an adjudication
How long you live in South Florida?
in 3 days.
Yes, Your Honor.
All right, Mr. Highland, state's offer right now is an adjudication of guilt. This would remain as a conviction on your record and 3 days Broward County Jail. Do you want to accept that offer?
I suppose so, Your Honor.
You suppose so? I can't accept that. I suppose that I can fly a plane. Are you going to go ahead and come with me to take, I'm going to take you to the Bahamas? No, I need to know for sure. It's a yes or a no. Not a suppose so, not I think so, not I believe so.
There's no chance for just a flat-out resolution and time served today?
Nope, nope, nope.
Then I accept the offer.
How is that a not under force of coercion?
Your Honor, and I can say all you can do is give him the colloquy if you're satisfied with his answer. I mean, I hear what the court's saying.
All right, Mr. Highland, would you please raise your right hand, sir? Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, you may place your hand down, sir. All right, Mr. Highland, are you under the influence of any alcohol, medication, or drugs?
No.
Okay, have you ever been treated for a mental illness?
No, Your Honor.
All right, can you read, write, and understand English?
I can.
All right, so you understand everything that's going on here today?
Come again?
You understand everything that's going on here today?
Yeah, I do, yeah.
Okay. All right, Mr.
I'm a little
Highland.
hard of hearing in one ear.
Okay. Mr. Highland, you've expressed an interest in resolving your case of trespass, other structure, or conveyance. The state's offer is an adjudication of guilt. This would remain as a conviction on your record, court costs, and 3 days in Broward County Jail. So depending on when you were arrested, which I believe was yesterday, you would be held in jail for another 2 days. Is that your understanding?
I do.
Okay.
I understand, Your Honor.
All right, and you wish to take this, the state's offer?
I'm accepting the offer, Your Honor.
All right. And you don't want to take this to trial?
No, I don't.
All right, and you understand that you have a right to speak to an attorney, and if you can't afford an attorney, one could be appointed to you by the court, but you wish to do this without the assistance of an attorney. Is that right?
Yeah, I'm going to represent myself, in other words,
All
yes.
right. Mr. Highland, are you on probation or parole anywhere in the world?
No, I'm not, Your Honor.
All right. And Mr. Highland, you understand that if you take the state's offer today, if you're not a U.S. citizen, you will be subject to deportation. You understand that?
Yeah, I understand.
All right. Mr. Highland, as to the charge of trespass, other structure, conveyance, how do you plead, guilty or no contest?
No contest, Your Honor.
All right, I accept your plea. I find that you're fully voluntarily entitled to waive your right to find that you're competent and learn. I find that you know only issue this plea and understand the nature of the charges and the consequence of the plea. After reviewing the charging document, I find that there's sufficient facts to basis for your plea and sentence you according to the negotiated offer of an adjudication of guilt, court costs, and 3 days in Broward County Jail with credit for time served. Thank you very much, Mr. Highland. Good luck to you. Take care.
All right.
Nahum Sticker or St. Sir?
That's North Broward, Your Honor.
Oh, North Broward. Thank you. How are you, Mr. St. Sir?
Kinda good, Your Honor.
All right. Mr. St. Sir, you're charged with exposing sexual organs in public. Any probable cause arguments? All right. I find probable cause for that charge. And as far as bond is concerned, Mr. Linder?
Your Honor, I'm just asking that the bond be kept in place. No victim contact. I can advise the court Mr. St. Cyr has a pending aggravated assault, a deadly weapon, and theft.
All right, very good. So the bond will be set at $100. Thank you very much, sir. Mr. St. Cyr, good luck to you. Nathaniel Martin?
Main jail.
All All right, back to the main jail. Mr. Martin.
Yes,
Welcome
ma'am.
you, sir. You're charged with touch or strike battery. Any probable cause argument? No argument. No. I find probable cause as to count one. As to count the convenience bond is set at $1,000. Mr. Linder.
Your Honor, let me see here. One moment, Your Honor. Okay. I'm fine with the $1,000 convenience bond, just asking for an order of no victim contact.
Judge, just so the court knows, he indicated that he may not be able to afford the $1,000. He's been a resident here all of his life. He has no money in the bank. He does have a job as a security officer. I would ask the court to just consider RORing him, and
Well, this
so that
charge
he
is going
can.
to certainly put a little snafu on your security officer's license.
Well,
yeah.
2012, he was convicted after a VOP for recruiting criminal street gang membership, sentenced to 2-year state prison. 2011, burglary of a dwelling and grand theft with a violation of probation, 2-year state prison. I'm not certain he's licensed as a security officer.
All right, I'm not gonna disturb the $1,000 bond, and I'm gonna order that there be no contact, no victim contact. Mr. Martin, you cannot have any contact with Miss Brittany Randall. You understand that?
Yes, ma'am. Yes,
right.
ma'am.
All right, take care,
Right,
sir.
thank you, Judge.
You're very welcome. Louis Altamar.
Reset. It's a Judge. That's a reset.
I did ask her.
Reset to tomorrow.
Can I get another paperclip, please?
Joseph Allwine.
Conti, Your Honor, Conti.
All right, we're going to Conti. Mr. Allwine, how are you doing, sir?
All right, ma'am.
All right, Mr. Allwine, you're being held on additional charges, counts 10 through 13. Counts 10, they're all for a capias on case number 160135525 CF10A. I get to set a bond on these?
Yes, he's being held to have a bond set, Your Honor. I'm just checking to see what.
I don't have the probable cause. Oh, yes, I do. Yes, I do.
Have these been filed yet, Your Honor, or are they the same ones that they just took off? I know.
Okay, hold on just a second. I find probable cause on those capiases, on those counts 10 through 13 on those capiases, seeing as how.
Your Honor, can I check one thing real quick, please?
Sure.
Thank you.
Oh, count 13, the bond should be 1,000. So Judge Siegel set a bond on just one count? Just the grand theft?
Okay.
Thank you.
Yeah. Your Honor, his other charges, he's got a total bond of $16,000 with a GPS monitor on 2 Berg conveyances, a Berg structure, and a grand theft. I'm just going to be asking for, on 10 through 12, $2,500 per count.
Your Honor, the only thing I was trying to clarify is they had 4 charges on me, and I was trying to clarify that they didn't file info them, and I was trying to make sure these aren't the same charges and they're getting confused.
They're not the same.
No, Your Honor, what happened was they were attached to the other charges. So what happened was we no-infoed the 4 counts and filed these under a separate case number.
Okay, so
But they're the
probably
same charges at work.
they're not
is
right.
what I'm
But no info those other accounts because probably when you were arrested on that Berg, on that other Berg,
Yeah.
don't talk to me about the facts of the case. I'm just letting you know procedurally this is probably what happened. They saw that you had these active warrants for other burglaries, so they just
No. What happened was when he was originally arrested, it was on multiple burglaries.
correct.
And they were originally all under one case number. And because these are separate from those burglaries, we no-infoed the counts and filed them under a separate case number.
Oh,
So they're the same ones, just a different case number that they know
Yes.
info. Okay, that's what I was.
Your pleasure,
Okay.
Mr. Allwine. You're great.
No, it's not my pleasure, I promise.
No, but you're a pleasure to deal with in light of the circumstances.
Excuse me, now, they're saying Judge Ziegler,
Siegel.
Siegel,
Judge
my
Siegel.
public defender told me it was Judge Robinson, which I'm I'm not sure if it was.
Well, and you
Well,
know
if
what?
it
If
was
these,
Michael Robinson or
if
you,
if
I don't know.
if these were and you know what? If these were randomly assigned, but the earlier cases were with Judge Robinson, then these will probably end up with Judge Robinson.
Okay.
Okay,
right.
that's what I was curious. I'm sorry to be
No,
such
no,
a
it's all
pain.
right. Okay, so let me go ahead and set the bond on count 10. You said you wanted 25 on each?
I'm just asking 2,500 on the first three, and obviously whichever one had the 1,000 set, obviously 1,000, and 2,500 on the rest.
And you're not capable of the one charge. The very first one I had was burglary of a conveyance, but they lowered it to attempted burglary of a conveyance. They got 5,000. Can they lower the bond on that to 20 to something?
No,
or is
not
that
today. But you can talk to your
Okay.
attorney about that one. That's a good one though. If they lowered it to an attempted.
Yeah,
certainly a good one.
nobody went in the vehicle. It was, okay,
Don't
thank
talk to me
you.
about the facts of the case.
Oh, I'm
All right.
sorry. I'm sorry.
That's okay. Count 10, I'm going to set the bond at $2,000. Count 11, I'm going to set the bond at $2,000. And count 12, I'm going to set the bond at $2,000. And count 13, I'm not disturbing the $1,000 bond. Mr. Alwine, it was a pleasure. Take care.
All right, thank you.
All right. Daniel Santiago Hernandez.
Main jail.
Yep. I need
And this is an ad chart, and I don't know if you have access to that computer.
I probably do, but I didn't log it up.
Because unfortunately, I'll try again. I'm having printer issues. I print you out a copy of the original report, but
Do you have a copy, Mr. Absalom?
I'm trying
Of the
again.
probable cause? Because I don't have a piece.
Yeah, it would be on the original. This charge wouldn't be there, but the allegations supporting it would be on the original PC.
All right, let's go ahead and put Mr. Santiago Hernandez on a brief recall, sir. We're waiting for them to get the arrest report so that I can get further information on your case. All right, if you'll just momentarily have a seat. Let's go ahead and take Madam Victim Advocate for the State Attorney's Office. Is that the victim advocate?
No, it's my sister.
Because we have some people here on behalf of Jaquan Harvey. Is that right? Okay. And I wanted to see if somebody was going to talk to her.
Well, one moment, Your Honor. Normally, was that a DV from this morning, Harvey?
No.
Because normally the victim advocate that's here only deals with
All right, well, let's
DV cases, but what I
All right, let's take Mr. Jaquan Harvey. Is that Mr. Harvey?
Yes, it is, Judge.
All right, very good. Ma'am, please come up to the podium. And I believe Mr. Jaquan Harvey was on page 21, for those of you that go down the docket. All right, Mr. Harvey, and you are, ma'am? Alicia Williams, you're his mom? All right, you're very lucky, Mr. Harvey. You have your mom here present on your behalf. You understand that?
Yes, ma'am.
All right. All right, Mr. Harvey, your count.
Judge, I have explained to him the two counts that he's charged with, just so the court knows.
All right, so I'll waive reading?
Yes, Judge.
All right, very good. So we'll waive reading of both counts. Any probable cause argument? All right, I find probable cause for both counts. And now, as far as the bond is concerned, Mr. Linder?
Your Honor, I see no record. However, based on the seriousness of the allegations, Your Honor, and potential consequences, I'm going to be asking for a $10,000 bond per count and no victim contact.
All right, Mom, is he going to be staying with you? How old is Mr. Harvey?
19.
You want $10,000 on each?
Your Honor, they are still second-degree felonies. Your Honor, I am concerned. I want to set a bond to ensure the victim's safety and that there's no content to reinforce a no-contact order.
All right, without talking to me about the facts of the case, Mom, what can you afford?
Not much.
Mr. Farber?
Judge, I can tell the court that he's lived here in South Florida all of his life. He has no children. He indicated that he works at McDonald's. He has no money in the bank. He does have family here, as the court can tell. His mother's here today. His family is supportive of him in that, but again, the bond amount, he really wouldn't be able to afford that much of a bond. I would just ask the court to take that into consideration when setting the bond. I also, Judge, I believe this is his first offense. I don't believe he's ever been arrested before.
No, right. It is his first offense. And you want $10,000 on each, or what did you say?
I'm asking for 10,000 per count, Your Honor.
How are you on these?
All right, Mom, what do you want to tell me?
Tell you about that story or?
No, talk to me about the facts of the case. I want you to tell me why I shouldn't give him a $10,000 bond on each count, so for a total of 20. Besides the fact that you can't afford it, I don't know that anybody has 20,000.
I know I'm a single parent, and both his father has passed in 2013. So it's basically his family. Like my mom's side is his family, because his dad's side don't come around. And
All right, I'm gonna give him on count 1, it's gonna be a $5,000 bond, and count 2, it's gonna be a $5,000 bond. All right, no conditions of pretrial release or anything like that. The bond.
We are going to ask for no victim contact.
I'm sorry?
does he go to court after that?
Yes, he's gonna get a court date, and I'm gonna order that he had no contact with the victim. Okay, no contact whatsoever with the victim in this case.
Your Honor, I would ask if you could advise Mr. Harvey and ensure that he understands the court's order.
All right, Mr. Harvey? Mr. Harvey, you understand that I'm gonna order that you have absolutely no contact with the victim. You cannot reach out to her through somebody else. You cannot reach out to her in Instagram. You cannot reach out to her on Facebook, nothing. You cannot have any contact with this victim, okay?
I understand.
All right. Thank you, sir. All right, thank you, Mom. Did we get the probable cause affidavit for Santiago Hernandez?
Yeah, Your Honor, I can tell you our printer is not working. I can proffer to the court. One moment.
All right, in the meantime, let's take Alex Rodriguez out of turn. We also have family here for him. That's on page 24.
Could you call up the ITU?
All right, Mr. Rodriguez, you're being charged with, and who are you, ma'am?
I'm his mother.
Okay, Mr. Rodriguez, you understand your mom is present?
Yes.
All right, you're very lucky. All right, Mr. Rodriguez, you're charged with 9 counts. Count 1 is grand theft, $300 to $5,000. Count 2 is grand theft, $300 to $5,000. Count 3 is grand theft, $300 to $5,000. Count 4 is burglary, unoccupied conveyance, unarmed. Count 5 is grand theft, $300 to $5,000. Count 6 is burglary, unoccupied conveyance, unarmed. Count 7 is grand theft auto. Count 8 is burglary, unoccupied conveyance, unarmed. And count 9 is grand theft auto. Mr. Upsall, any probable cause arguments?
Judge, he indicated that he's hired private counsel.
Oh, all right. And where's the attorney, Mom?
I don't know. I don't have the attorney's number. He does.
All right. Who's your attorney, sir?
Angel Ruth?
Angel Ruiz?
Yeah.
All right. Have you reached out to him, sir?
No, not yet. But he knows I'm in.
Okay. So you want to roll it over at Mom? Can you give your mom his phone number, his information, so that we can roll it over to 1:30 to give him an opportunity to appear here on your behalf if you're going to hire him? Otherwise,
really
there are a lot of charges that you're charged with, and I don't know if you're legitimately gonna get this attorney. I think that he would want to have an opportunity to go ahead and address these charges on your behalf.
What? Do I really need him right now, or?
We're just trying to get a bond set for the other 3 charges for right now.
Yeah.
He already has for the other 5 charges $1,000 bond.
Which can go up. There's no guarantee. Those are convenience bonds. Depending on what the state says, it's a non-adversarial hearing, so it's not like you're going to be able to argue regarding, anything like that. The court takes into consideration your ties to the community, any priors that you may have, any capiases, failure to appears that you have in your past. So that's why I'm saying, if you want an opportunity to have your attorney, if you're going to get your attorney here, I will give you that opportunity. Otherwise, if you want to proceed without your attorney, we can do that as well. Or if you want to proceed with the public defender's office, you can do that as well. It's up to you, sir. But I'm giving you these options, but we're not going to proceed until you tell me what you want to do.
If I proceed with the public defender's office, can I get the lawyer later or no?
Sure.
Okay, I will go with the public defender's office.
All right, Mr. Fairberry?
Yes, Judge. I'll give me a minute to talk to him.
Absolutely.
Can they hear what I say, Your Honor?
Not right now, but now they
Can
can.
you ask him to address you as yes, ma'am, or no, ma'am, or yes, Your Honor, or no, Your Honor? I don't like how he's addressing you right now.
Oh, I didn't.
It's not very nice. And I taught them better than that.
I do appreciate that, Mom. I didn't catch that.
I don't want to publicly humiliate him in front of all those guys as his mother.
Oh, maybe sometimes that's what people need, a little bit of a grounding moment. All right, ready?
Okay, Judge. I'm ready. Judge, I can tell the court.
Well,
Go ahead,
just
I'm sorry.
as I previously had asked, any probable cause arguments, there were none, so I find probable cause for counts 1, 2, 3, 4, 5, 6, 7, 8, and 9 probable causes found. As far as the bond is concerned, Mr. Linder?
Your Honor, I can tell you, last year as a juvenile in Dade, he went through a diversion program on a similarly related offense, felony offense. He looks like he just completed it, the program November 15th of last year. Your Honor, I am concerned it does not appear this is an isolated incident. There definitely appears to be a pattern here in this evening. Three different cars broken into. Significant value of at least one of the vehicles. Your Honor, I'm concerned for the safety of the community, specifically the property of the community. I'm going to be asking for $5,000 bonds on count 4, 6, and 8.
All right. So here's what's going to happen procedurally. Mr. Fairberry has had an opportunity to speak to Mr. Rodriguez, and then, Mom, I'll go ahead and give you an opportunity to talk to me about that bond as well. Mr. Fairberry.
Judge, I would indicate to the court that he's lived here all of his life, that he is single, he has no children, he has no money in the bank at this time, he works shipping cars out of the country, that he does have family members here, not only his mom, but his grandparents live here also. I would just ask the court, I don't believe they have a lot of money to afford bond. However, I would ask the court to keep the $1,000 on everything that's already been set. With regards to the hearings, we would ask the court to set a bond at $1,500 on each of those 3 counts. I don't know that he'd even be able to afford that, but that's what we would ask.
All right. Mom?
Yes,
Does he live with you?
He actually lives with his grandparents, helping to take care of them. I agree with the requested bond amount. I respectfully disagree with the state attorney that he's a danger to the community. He just got caught up with the wrong person again just recently,
I don't
and
want
I've
to
warned
talk about
him.
the facts of the case.
Right, but he's got sidetracked, and I've warned him before, and I don't believe that he will do this again. I firmly don't believe he will ever do this again. This has been a learning experience.
So the only prior that he has was as a juvenile.
Yeah, I mean, if we can go sidebar real quick.
All right. We'll go sidebar momentarily. All right, we're back on the record, and Mr. Rodriguez, you're very lucky. I want to emphasize how lucky you are that your mom is here because she's speaking on your behalf. She's trying to advocate on your behalf, which is more than I can say for a lot of other people. A lot of other people's parents don't show up, so I suggest that when and if you do get out of custody, that you go ahead and buy her a coffee to thank her for being here on your behalf. Understood? All right. So, all right, having heard argument, I'm not going to disturb the convenience bond on counts 1, 2, 3, 5, 7. I'm gonna leave those bonds, and 9, I'm gonna leave those bonds at $1,000. As to counts 4, as to count 4, 6, and 8, I'm gonna set the bond at $1,000 on each count. And I'm gonna order, just to ensure that Mr. Rodriguez stays on track, I'm gonna order that he be put on level 2 electronic monitoring, which means that you're gonna be wearing an electronic monitor, so they're gonna be able to know exactly where you're at all times. You're gonna be able to go to work. I'm gonna order that you do not return to any of these businesses or properties, and that's it. All right?
And the court's going to order, obviously, Your Honor's ordering no victim contact.
Correct, and no victim contact as
Thank you,
well.
Judge.
You're welcome. Thank you, Mom. Thank you, Mr. Rodriguez.
Thank you.
Okay. All right.
Well, I could see, and frankly, I couldn't tell if they were if they were from businesses or individuals, so that's why I'm just asking for no victim contact.
No contact. Yeah, no contact because.
Well, I was just going by the addresses listed on the probable cause affidavit.
All right, we're back on track, hopefully. Kyle Wagner.
Conti, Your Honor.
All right, thank you. All right, Mr. Wagner, good afternoon, good morning. Mr. Wagner, you're charged, you were charged with a charge of grand theft, $300 to $5,000. Any probable cause argument? All right, I find probable cause for that charge. Any, Mr. Linder?
Your Honor, I believe he's in SAP right now, so I'm just asking that the $1,000 bond be kept in place.
All right, I'll leave the bond at $1,000. Good luck to you, Mr. Wagner.
Thank you, Your Honor.
You're very welcome, sir. Christopher Rhodes.
Conti again, Your Honor.
All right, thank you. All right, Mr. Rose, good morning, sir. You're being charged with counts 4 through 17. Count 4 is a burglary, unoccupied structure, unarmed. Count 5 is a grand theft, $300 to $5,000. Count 5 is a burglary, unoccupied structure, unarmed. Count 7 is a petty theft, this is second degree. Count 8 is a burglary, unoccupied structure, unarmed. Count 9 is a burglary, unoccupied structure, unarmed. Count 10 is a burglary, unoccupied structure, unarmed. Count 11 is a burglary, unoccupied structure, unarmed. Count 12 is a burglary, unoccupied structure, unarmed. Count 13 is a criminal mischief over $1,000. Count 14 is a burglary, unoccupied structure, unarmed. Count 15 is a grand theft, $300 to $500 to $5,000. Count 16 is burglary, unoccupied structure, unarmed. And count 17 is a petty theft in the first degree. Any probable cause arguments, Mr. Afzal?
Don't, Judge.
All right, I find probable cause on count 4, count 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. Probable cause is found. As far as the bond on each count right now, the convenience bonds are set on count 5, on count 7, on count 13, on count 15 and count 17. Those are convenience bonds of $1,000 for that grand theft, $25 on that petty theft, $500 on that criminal mischief, $1,000 on that grand theft, and $100 on that petty theft. Mr. Linder, any?
Yes, Your Honor, and I'm not asking for any modification on the charges out of convenience bonds.
Okay.
And
So those bonds will remain the same, just to go ahead and just move this along. So
yes, and Your Honor, I'm going to be based on his criminal record, which I'll provide to the court. I'm asking for $10,000 per count on the burglary charges. 2013 burglary of a structure and grand theft, 49 months state prison as a habitual offender. 2013 burglary of a structure, grand theft, and attempted burglary of a structure, 49 months state prison as a habitual offender. 2013 burglary of a dwelling and felony theft, 49 months state prison as a habitual offender. 2012 burglary of a structure and grand theft, 49 months state prison as a habitual offender.
Judge, there is a parole hold violation. 10,000. That's a lot. I would ask the court to significantly reduce that.
Frankly, Judge, I don't think it's a lot, considering that from 2012 until now, and most of that time he's been in prison, 5 burglaries, classified as a habitual offender, 49 months state in prison, and now here for violating his parole on burglary by committing all these burglaries. Frankly, I think it's very reasonable.
He's being held on no bond for those violations of parole? Is that right?
Yes.
Okay. It's not really going anywhere.
The thing is, unless there's a change of circumstances, the 10,000, I'm just asking the court to just reconsider that. I'm not giving him out, just maybe less than that. That's all.
Well, Your Honor, I'm not trying to make an argument for the defense, but if his parole is resolved with his ability to then bond out, then that would be a change in circumstances. And I'm just asking, taken separately, I think they're just appropriate, considering, his criminal record is horrible with regards to burglaries. And now he's here for the same exact thing on multiple burglaries.
All right. All right, count 1 will be set at 7,500. Count 2 will be set at 7,500. Or no, I'm not. I'm not modifying it, sorry. Count 4 will be set at 7,500. Count 6 will be set at 7,500. Count 8 will be set at 7,500. Count 9 will be set at 7,500. Count 10 will be set at 7,500. Count 11 will be set at 7,500. Count 12 will be set at 7,500. Count 14 will be set at 7,500. And count 16 will be set at 7,500. Thank you, sir. Good luck to you.
And no victim contact, Judge,
And no
please?
victim contact.
Thank you.
Thank you, sir. Anthony Thomas. Yep, all right, Mr. Thomas. Sir, you are charged with count 1 is aggravated battery with a deadly weapon. And count 2 is a violation of probation. I find probable cause for that VOP, and then that VOP you're being held no bond. I can't disturb that. Good thing is you're going to go see your division judge on January 18th, 2017. As far as the aggravated battery with a deadly weapon, any probable cause argument?
Your Honor,
All right, I find probable cause on that charge. And as far as the bond?
one moment, Your Honor. Did you have a probable cause affidavit attached?
It was a not in custody, so
I have it here in Odyssey. I don't know why it wasn't attached to the paperwork. If you'd like, I could proffer to the court.
Yeah, go ahead.
This is a domestic violence case. I'm just reading literally from the PC. Above defendant and victim used to date and have one child in common. Defendant came by victim's place of employment and attempted to get the victim's attention. Once defendant realized that he was being ignored, he grabbed her shirt and then pushed the victim to the ground. Victim quickly got up and the defendant brandished a sharp blade and swung it in the direction of the victim, cutting her right index finger. Victim suffered a half-inch laceration to her right index finger. Defendant fled the scene prior to law enforcement's arrival. As far as his criminal history, one moment. Okay, Your Honor, in 2015, he was arrested for shooting at, throwing a deadly missile, and battery. That was against the same alleged victim. The charge was dropped. 2015, possession of cocaine. He was convicted. 2012, tampering with evidence, resisting without violence. 2008, possession of cocaine. 2008, possession of cocaine. 2002, possession of cocaine. 2002, loitering and prowling. 87, two deliveries of cocaine. He has some drug priors earlier than that. I won't get into that. Your Honor, based on the level of violence, it's his second arrest, recent arrest for violence against the same alleged victim. I'm going to be asking for a $10,000 bond on count 1, no victim contact.
Mr. Farber?
Judge, in light of the fact that he has the no bond hold, I would ask the court to set a reasonable bond, something in the neighborhood of $2,500 to $3,500, but he's not getting out anyway because of the no bond.
What was your recommendation, Mr. Mayor?
10,000, Your Honor. And also forgetting to mention that he was on probation when he allegedly committed this violent offense.
All right. I'm going to set that bond at $7,500 on count 1, and count 2, as I mentioned, is a no bond. Thank you.
Thank you, Judge.
You're welcome. Willie Williams?
How you doing?
Private attorney.
All right, Mr. Williams, you're being charged with count 1 as burglary of an unoccupied dwelling unarmed. I find probable cause on that not in custody capias that was signed by Judge Merrigan. Counts 2 and 3 are out of county holds. Count 2 has a no bond, which I cannot disturb, and count 3 has a bond of $31,000, which I can't disturb either. As far as count 1 is concerned, let me hear Mr. Linder on the bond.
Judge, he indicated that he's going to hire private counsel.
Oh, all right. All right, Mr. Williams, do you want an opportunity to have your attorney present?
Yes.
All right, where's your attorney?
Right now, I'm in a process of getting one.
Okay, well, at this hearing right now, we're going to be discussing count 1 and the bond that would be held, that you'd be held on count 1. If you want an opportunity to get your attorney present, I can roll it over to this afternoon or tomorrow, perhaps, to give you an opportunity to have your attorney come. But if you don't, then you want to proceed without an attorney, without your attorney?
I'll just proceed.
Okay. All right, Mr. Linder?
Your Honor, the state is going to be seeking a $25,000 bond. First off, I'd like to advise the court that as of, one moment, Judge, July 1st of 2015, according to the Florida Department of Law Enforcement, Mr. Williams is registered as a gang member. Additionally, his prior record out of Palm Beach County, 2013, burglary of a structure, credit card fraud, grand theft. He was sentenced to a year and 8 months state prison. His most recent release from state prison was January 4th of 2017. As you can see, he's wanted for similar offenses in Lee and Dade County. Additionally, 2013 out of St. Lucie County, he was convicted of 3 counts of fraudulent use of personal identification information, credit card fraud, grand theft, possession of burglary tools, fraudulent use of personal ID, grand theft, fraudulent use of personal ID and grand theft, sentenced to 2.5 years state prison. 2013 out of Martin County, credit card fraud, 18 months state prison.
All right, Mr. Williams, the state is asking for a $25,000 bond on count 1.
All right.
Talk to me about the facts of the case. Can you afford that?
No, Your Honor.
All right, what can you afford?
A little bit lower than that.
$24,000?
$10,000.
What, you have a job?
No, Your Honor. I've been locked up since 2013.
All All right, count one is going to be a $20,000 bond. All right, Mr. Williams, good luck to you, sir. And no victim
All right.
contact. You cannot go back to
All
that
right.
gentleman's house, all right? All right, let's go ahead and call Daniel Santiago Hernandez. I got the case up.
Okay.
All right, so that was a case on case number 16014193 CF10A.
Yes.
I find power cost for the capias as far as the probable cause was already found and it was already held.
Not on this count, though, Your Honor.
Not on this count.
It's an ad charge, Your Honor. As you can see, I don't know if you pulled the information, but it's based on his possession of the knife in the aggravated assault.
All right, so what's the state's position on bond?
Your Honor, currently Mr. Santiago Hernandez is being held on total bond $15,000 on the ag assault, $5,000 on the burg conveyance, and $5,000 on the other burglary conveyance. Be requesting a $2,500 bond on this charge.
All right, Mr. Farberic?
Judge, he didn't sign any of the paperwork this morning, so I'm not sure if he wants a public defender or if he is going to represent himself or what his status is.
All right, there is a notice of a public defender assignment on the case. So it looks like the public, and there's an affidavit of indigency.
Okay, if I can have 1 second to talk to him.
Sure, thank you, Mr. Farberic.
How long have you lived here in South Florida? Mary?
You're not muted. You're not muted.
You're not muted, Mr. Farberic.
Okay. Sorry, thank you.
You're welcome. Did you get a hold of the Creole interpreter?
I'm calling it right now.
Yes, Coke Zero. Not right now for you. Coke Zero. All right. All right, so, Mr. Farberic?
Judge, I did have a chance to speak to him. He indicated that he's been a resident here all of his life. He is single, he has no kids, he has no money in the bank. He's currently not working, but he's trying to get into IDT Tech. He wants to study engineering, and he's trying to get a degree through them. He does have family members that live here. He has an aunt that lives in the area. Based on that, we would just ask the court to set a reasonable bond in this case. I know he has bonds on the other case. The total, I think it was $25,000.
Yep.
So I don't know if the court would set a lower bond, maybe $1,000, something like that. Just I don't know that he's going to be able to post bond on the $20,000 that's already been set.
All right, I'll set the bond on this case at $1,500. Thank you.
Thank you, Judge.
You're welcome. Lawrence Yoakum?
He declined PD.
All right, Mr. Yocum, you're being held on a violation of probation on a case 16002322CF10A. You're being held no bond on that case. I find probable cause for the VOP. You're gonna go see your division judge on January 18, 2017. Good luck to you, sir. Thank you.
Thank you.
Michael Morrow. Michael Morrow, Mr. Morrow is coming up. All right, Mr. Morrow, you're being held on a violation of probation on case number 1406462CF10A. I find probable cause for that VOP warrant. And you're being held no bond. And you're going to go see the division judge January 18, 2017. Good luck to you, Mr. Morrow.
Thank you.
Mark Metcalf.
Judge, he also declined PD.
All right. Mr. Metcalf, you're being held on 2 cases. Both cases are on case number 1201567CF10A. That's counts 1 and 2. Those cases, I find probable cause for those 2 cases as that judge signed it, and that just signed it holding you no bond on those cases, so I'm not touching those as well. Good thing is that you're going to go see your division judge January 18, 2017. Good luck to you, sir. Thank you.
January what?
Gene Bart. All right, Mr. Gene Bart, you're being charged with criminal mischief over $1,000. Any probable cause argument? All right, I find probable cause for the criminal mischief charge as far as the convenience bond of $500. Any reason why I should touch it, Mr. Linder?
I'm asking that it be kept in place.
Mr. Farberg?
Judge, I can tell the court he's lived here for 36 years. He's divorced. He has no children. He has a little bit of money in the bank. He does work for a car wash. He asked me to ask the court if the court would consider releasing him to pretrial release.
Mr. Linder.
2008 trespass, 2008 battery, resisting without violence, disorderly conduct, 2008 resisting without violence, 2008 theft, 07 disorderly intoxication, 02 disorderly intoxication. Just note, I understand Mr. Farberg just informed either he was working at a car wash. It appears that's where he happened. He damaged one of the customers' vehicles.
No, I'm still. No.
I show that this defendant was in prison and released up to Polk County.
Up in Polk County, June of last year, he was in prison and released. All right, I'm not touching that bond. I'm leaving it at $500. Thank you.
And that's for, Your Honor, I'd ask for no victim contact.
And no victim contact.
Thank
and
you.
No return to the place of business.
You can't.
All right, Antonio Barnes. Antonio Barnes. All right, count 1, Mr. Barnes, you're charged with driving while license suspended as a third or subsequent offense. Count 2 is felony battery. And those were warrants.
They're actually, I think it appears he is eligible for bond on counts 2 and 3, Your Honor.
Yeah.
I know it says no bond on
Probable
there.
cause on count 2 and 3, which is criminal mischief. That's on case number 160104448CF10A. Any argument on probable cause for count 1? All right, probable cause, I find probable cause on count 1 as well. The count 1 has a convenience bond of $750. Any reason?
I'm not seeking any modification on count 1, Your Honor.
All right, count 1 will remain at $750. Let's hear about count 2 and 3.
Your Honor, one moment. Okay. It appears his prior battery was against the same alleged victim in 2013. There was also a charge of strangulation attached to that, and that was dropped. He was arrested in 08 for domestic violence battery against a different alleged victim. That was dropped. Based on his prior involving violence against the same alleged victim, I'm asking for a $5,000 bond on count 1, Your Honor. I'm not asking for any bond on the misdemeanor on count 3. And obviously no victim contact.
All right, Mr. Farberg, they're asking for $5,000 on count 2, the felony battery, and on count 3 was what?
I'm fine with an ROR on the misdemeanor on count 3.
Judge, I can tell the court he's lived here all of his life. He's single. He has no money in the bank. He has a job that he's going to begin working on January 25th at a restaurant where he'll be a cook. So he can't, obviously he has no money. He can't get the money until he gets out and works. What I would ask the court is that the court would ROR him with regards to count 3. On count 2, I don't know if the court could set like a $1,500 bond on that.
All right, count 3 will be an ROR, and count 2, Mr. Barnes.
Yes.
I'm gonna go ahead and give you a bond momentarily, but I want to order you, Mr. Barnes, you're to have absolutely no contact with Sade Denise Trey, okay?
Yes.
You cannot
Okay.
contact her. You cannot have somebody else contact her on your behalf, because if you do, you're gonna keep getting yourself. You're gonna end up right where you're at right now.
Okay.
All right. As to count 2, I'm gonna set that bond at $3,000. Thank you, sir.
Okay. Oh, okay. So
Joshua Kelly.
375.
All right, Mr. Kelly, good morning. You're charged with a violation of community control and felony case number 150098003CF10A. I find probable cause for that violation of community control warrant, and you're being held no bond on that case. Good thing is you're going to go see your division judge on January 18, 2017. Good luck to you, sir. Ace Vergara.
Judge, he indicated he has private counsel.
All right, Mr. Ace Vergara, where are you at? Okay.
Thank you.
We do that.
All right, Mr. Ace Vergara, where's your attorney?
No bond, because we did a motion.
I don't remember it, sorry.
I'm sorry? You need to speak up, sir.
I don't remember the name of my
Yeah,
son.
You don't remember his name?
No.
I think I may be able to get it, Judge. Oh, actually, wait one moment.
I would hope he'd remember his attorney's name.
Mm-hmm.
All right, so Mr.
I
Ace-
believe he's referring to Larry Wolk.
Oh,
Well, not today.
Is he referring, if you want to inquire if he's referring to the attorney currently representing him on his pending case?
are you referring? Do you have an attorney representing you on a pending case, Mr. Ace Vergara?
Yes.
Okay, and that's Mr. Larry Wolk.
Yep.
Okay, was he appointed by the court or was he?
Just substituted in.
Oh, so okay. All right, are you going to get Mr. Wolk to represent you on this case?
Yes.
Okay, because here's the thing, Mr. Ace. If you want to proceed without your attorney present, you can do so. But right now you're looking at the convenience bonds are setting. You're looking at $80,000 in bonds that your attorney perhaps may want an opportunity to address with you. If you want, I can roll you over to this afternoon to give your attorney an opportunity to appear on your behalf, or you can proceed without an attorney if you like.
I gotta keep it my son.
I'm sorry?
I gotta keep it my son.
You want to speak to your attorney?
I gotta keep it my lawyer.
Well, Your Honor, what I would ask is, under the rules, if you want to give Mr. Vergara an option, because seeing where he's being heard on the docket, we're going to be back in 2.5 hours. I have no objection if he wants to reset it for tomorrow morning.
All right, listen, Mr. Ace Vergara, we're going to reset this to tomorrow morning to give you an opportunity to get a hold of your attorney. I'll ask somebody to let your attorney know that you're here, and hopefully he'll show up on your behalf tomorrow morning. Okay, sir?
And I'll call Mr. Wilkes' office drawer.
I appreciate that, Mr. Linder. Thank you very much. Thank you, sir.
Want me to your office? What? The guy in your office? No, Larry Wolk. He's a private attorney. He's a private attorney.
Yeah, I'm sure. Thank
Andre Lambert. All right, Mr. Lambert, you're charged with 4 counts. Count 1 is dealing in stolen property. Count 2 is dealing in stolen property, and count 3 is false owner information to pawn items, $300 or more, and count 4 is false owner information to pawn items, $300 or more.
Judge, Mr. Lambert also indicated he's going to hire private counsel.
All right. Very good. Mr. Lambert,
Okay,
do you want
well,
an opportunity
not
to have your
sure.
attorney present today?
I don't know if I'm even going to be able to get an attorney, Your Honor. I was discussing it with them. I'm not sure if I'll be able to afford it.
I can't hear you. What?
I don't know if I'll be able to afford an attorney. I just was mentioning to him that I would try to see about getting one. But I would like to know about taking this bond, about pretrial relief.
All right, well,
the pretrial relief,
listen,
talk to me
first
about
things
it.
first, Mr. Lambert, first things first. Do you want me to provisionally appoint the Public Defender's Office to represent you in this
Yes.
case? Okay, so the
Yes.
Public Defender's Office is provisionally appointed on Mr. Lambert. Thank you very much, Mr. Fabricant. That's a quick service. Any probable cause arguments as to counts 1 through 4? All right, I find probable cause on counts 1 through 4. As far as the bond right now, is the convenience bond at $3,500 each. Mr. Linder?
Your Honor, I'm asking that the convenience bonds be kept in place. I think even in a best case scenario for Mr. Lambert, the aggravating factors considering his record would break even with any mitigating factors. I think it's more likely the aggravating factors outweigh mitigating factors. 2009, 2 counts of uttering a forged instrument, 2 counts of grand theft, VOP, 24.5 months state prison. 07, possession of cocaine with a VOP, 48 months state prison. 06, possession of cocaine with a VOP, 48 months state prison. 06, possession of cocaine with a VOP, 48 months state prison. 06, dealing in stolen property, burglary of a structure, and grand theft with a VOP, 48 months state prison. Theft, 97. Traffic, fleeing and eluding, 88. Resisting without violence, loitering and prowling, 88. End of record.
Mr. Farberic?
Judge, I can tell the court that he's lived here all of his life. He is separated. He has no money in the bank. He is self-employed. However, he had an accident last year where 3 of his fingers got severed. He's hoping to get back to work so that he can begin to earn money again. That he indicated that he has no money to afford any kind of bond. He's asked me to ask the court if the court would consider either RORing him
No,
or releasing
that's
him
not
to
gonna
free trial.
happen. Let's be realistic. And I'm sorry to
Or
cut you
to
off,
release-
Mr. Farberic.
That's okay, no problem. Or to release him to pretrial release. That's what he asked. He said he's not able to afford any amount of bond.
No, based on those priors,
Can we
Mr.
reduce
Lambert,
the
I
bond
can't do
down?
that.
Can we reduce the bond down?
And Your Honor, frankly, I would even have to say Mr. Lambert's claim, for instance, that he has no money has to be taken with a grain of salt. In this case, he was, for one watch alone, was given $4,000. He has a history of dealing in stolen property. In return, I would imagine for cash, based on his history of theft and crimes of dishonesty, I don't know how much credibility he really would have with the court.
All right, Mr. Lambert, you're lucky I'm not raising those bonds. I'm going to leave those bonds at each at $3,500 each. That's 1, 2, 3, and 4. I'm not going to disturb those convenience bonds. Thank you very much, sir. Good luck to you. Julio
Thank
Gonzalez.
you, Judge.
And then it's going to be Joshua Mack, then Armando Perales Crespo, Benji Alcine, Richard Bento, Joshua Newbold, and Stephen Brown. So line up in that order, please.
I'm just looking for
All right, Mr. Julio Gonzalez, you're charged with count 1 is grand theft, $300 to $5,000. Count 2 is grand theft, $300 to $5,000. And count 3 is burglary of a non-occupant conveyance, unarmed state. Sorry, Mr. Absol, do you have any?
Yes,
Judge,
I didn't see anything about
Judge,
this.
if I could really quick, he indicated that he has a private attorney, Richard Perez. He's not present in court right now, but he did want to have a chance to speak to him.
All right, so you want me to reset it to tomorrow morning to give him an opportunity to be here for you, Mr. Gonzalez?
Can you?
He's asking that we represent him at this point.
Okay.
I don't know if he's retained. I don't know if the attorney's retained. He has the name, so.
Have you hired this attorney to represent you in this case, Mr. Gonzalez?
He's indicating that he paid him money.
Hey, who was it that you wanted to line up? I think you said so fast, I couldn't understand. Your battle was up like 5 days.
Oh.
Does he have an attorney or not? Do we have it? We would have it, right, okay. All right, Mr. Gonzalez,
Yes, ma'am.
if you have an attorney, the Public Defender's Office can't, if you've already retained an attorney, the Public Defender's Office cannot represent you on this because that would be unethical for them to possibly poach a private attorney's client. I don't,
Alrighty.
that would be very.
Can I represent myself or no?
Yes, but if you have an attorney, I would strongly advise you, if you're paying for this attorney, why don't you, right now,
I already spoke with my attorney. I'm just pretty much looking to see if I can get a bond amount set for the burglary.
okay.
We'll set him up. Jeff set him up.
Alright.
They're just filling out like booking any information. They just have to book any information. His address is blank, Joseph Bird, all blank. And they have stuff here.
All right,
Yeah,
I
it's
find
recorded.
probable cause on counts 1, 2, and 3. As far as Bond amount, Mr. Linder?
Your Honor, this is Mr. Rodriguez's co-defendant. I'm just going to ask that the same bond. I believe you placed $2,500. I might be mistaken. I think they were.
Oh, this is Mr. Rodriguez, the 19-year-old?
This is Miss. Yes, this is one of his co-defendants. Yes.
Oh.
Yes. I believe it was 2,500. Is it that? Oh, okay. Your Honor,
I also put him on pretrial release level
yeah,
2.
and so I'm just
Based
saying.
on his mother's representation, based on his mother's
Yeah,
testimony being here.
that is true, Judge. So.
And you're 18 years old, Mr. Gonzalez?
Yes, I am.
Who do you live with?
I live right now with my girlfriend and my mother.
Any priors?
There was a juvenile prior. It got dropped. It wasn't related though to these offenses either.
I'll do the same. I'll give him $1,000 bond with level 2 electronic monitoring.
Thank you, Judge.
And we just.
It could be done.
$1,000 with level 2
Monitor.
I don't know, but you
pretrial release with level 2 electronic
You mean 1,000 on 3 with?
with pretrial release. If
So the
he's
total
able to
bond will be
close-
3,000. Because on 1 and 2 is the convenience bonds were 1,000.
Did I say 2? I'm sorry, did I say? Okay, 1 and 2 remain the same, $1,000, and 3 is $1,000 with pretrial release and electronic monitoring. I'm sorry. All right, thank you, sir. Good luck to you. Joshua Mack, come on up. All right, Mr. Mack, you're charged with carrying a concealed firearm, and count 2 is a violation of probation or community control. I've had probable cause for that BOP, and that is, and you're being held low bond on that. I can't touch that. As far as probable cause arguments for carrying the concealed firearm, Mr. Absol?
I don't know why they haven't showed up.
All right.
Judge, he
probable
indicated that
cause?
he indicated he declined PD also. Sorry.
Oh, okay. Mr. Mack, you've declined the probable cause, the service of the public defender's office. Are you gonna get yourself an attorney?
Yes, I have an attorney.
Who's your attorney?
Eric Stufel.
Eric Chappelle. Have you contacted him to let him know that you're here?
I gotta call him when I leave here.
Oh, well, you're not going. Well, when you leave that room,
No, I know,
or when you
I-
leave the jail, because you're not going anywhere. Because you're being held no bond on count 2.
Yeah, I know.
Oh,
I
okay,
know.
okay. So you want me to give him an opportunity to be here on your behalf tomorrow? You want me to reset this for tomorrow? You're
You
not going
can't.
anywhere.
Yeah, I know.
All right, so we'll
When
reset.
when do I see the judge?
I don't have that information yet, sir, but I can reset this and roll it over to tomorrow to give you an opportunity to contact your attorney.
All right.
All
That's
right.
cool.
See you tomorrow. Take
All right.
care. Armando Perales Crespo.
Bonded.
All right, very good. Benji LC.
Yeah.
Ooh, I skipped somebody. I'm sorry. Benji Elstein, go ahead.
Morning, Your Honor. He bonded.
All right, Mr. Elstein, you're charged with petty theft. That is a second-degree misdemeanor. Actually, I'm sorry. A second offense is a third-degree felony. Any probable cause argument?
What did we do on current?
All right, I found probable cause for the charge. As far as the convenience bond is set at $750 right now. Any argument?
I'm not asking for any type of modification.
Mr. Fairberry?
Judge, I would just tell that if I can have 1 second. Okay. Judge, he's lived here almost all of his life. He's married. He has no children. He indicated to me he has no money in the bank. He does have family members. His mom and his grandmother living here. He asked me. He indicated he can't post a $750 bond if he doesn't have enough money. I don't know if the court could consider something lower than that.
2016 trespass, 2016 trespass, 2015 theft, 2015 trespass, 2014 theft, 2013 trespass, 2013 trespass, 2010 grand theft auto with a VOP, 2010 grand theft with a VOP, 2005 unlawful use of false name ID, 05 unauthorized use of a driver's license or ID under the name Michael Sanford, possession of marijuana 04 under the name Michael Sanford, theft and trespass 04, theft 02 under the name Samuel Joseph, grand theft resisting without violence 02 under the name Samuel Joseph, unlawful use of false name ID 01, grand theft 01 with the VOP, unlawful use of false name ID theft 01.
All right, I'll lower the bond to $500.
Thank you, Judge.
Thank you. Good luck to you. Nathan Kerwick. All right. Mr. Kerwick?
Yes, ma'am.
Nathan Kerwick. Count 1 is grand theft auto. Any probable cause argument as to that? All right, I find probable cause as to count 1. Count 2 is a violation of probation in case number 160090009CF10A. I find probable cause for that VOP. Count 3 is another violation of probation or community control in the same case number, and you're being held no bond on those 2 cases. I can't disturb those bonds. You're going to go see the division judge on January 18, 2017. As far as the grand theft auto, that convenience bond is set at $1,000. I'm not inclined to disturb it unless we hear arguments. Mr. Linder?
No, I'm fine with that.
All right, Mr. Barbaric?
Judge, in light of the fact that he has no bond holds, I would just ask that you set a reasonable bond.
All right, I'll leave it at $1,000.
These are the same case numbers?
Yeah.
So it's 2, you must have had 2 counts. When you
call
put out,
Mr.
you must have had a grand 2 grand
Let's recall
theft.
Mr. David Pardue. The Creole
You play out
interpreter
2
is
grand theft
present.
for 1 case number?
No.
They'll get it squared away when it's there. Sometimes these dockets are wrong, but it's the same case number. They're not trying to say you have more than 1 case number.
That's the Creole interpreter case? Yep. All right, Mr. Pardue. All right, sir, interpreter, would you please raise your right hand? Do you swear or affirm that the interpretation you're about to give from English to Creole and Creole to English shall be the best to your ability, truest and accurate?
Yes, Chief British Certified Code Interpreter.
Thank you very much. All right, Mr. Pardue.
Monsieur Pardieu.
You are being charged with 1 is a writ of arrest.
Eh bien, ils ont accusé parce
That
qu'ils
bond
n'ont pas
is set at
timbré, ils ont voulu pour arrêter.
$300. It is not for
amendé
magistrates to
$300.
disturb.
Et ils ont demandé pour payer parce qu'ils ont fait déranger la paix publique.
Count 2, you're being held on a capias
Et puis, deuxième chef d'accusation, il y a quand même parce que gagné un
for
mandat d'arrêt que des
1401850
un dossier qui 003 MTA.
and that bond was set at $500 by the division judge, which I'm not disturbing.
Un mandat de $500 a été fixé pour dans le premier dossier.
I find probable cause on both charges.
Nous
and,
avons une bonne raison valable pour tous
the
les
good
deux
thing
cas.
is, you shall see your division judge on January 19, 2017.
Eh bien, date qui 19 janvier, ils ont fixé pour aller devant le juge naturel ou monsieur bonne chance.
Okay.
Once it's paid, you'll get out.
When
You just have to pay it, yeah. You just got to pay your bond.
Does anybody need the services
That's a
of the
traffic receipt.
interpreter?
That's not
Est-ce qu'il y a un monde là qui a besoin de service interprétateur qui parle créole?
That's it. I can't. That's it. I don't know what this goes
That's
to.
what they have me with today.
Okay, if you're.
I guess not.
Yes, ma'am.
Thank you, sir.
Thank you, Your Honor.
All right, Richard Bento. All right, Mr. Bento, welcome, sir. You are charged with count 1 is grand theft, $300 to $5,000, and count 2 is uttering a false instrument. Any probable cause argument, Mr. Upsall? All right, I find probable cause as to both counts, and right now the convenience bond is set at $1,000 on each count. Mr. Linder?
Your Honor, I have no argument for modification.
Okay. Mr. Barbaric?
Judge, he's been a resident here for 8 years, that he has no children, he's single, he has no money in the bank. He does work down at the stadium. He asked me to ask the court if the court would consider pretrial release.
Mr. Linder, any priors?
I don't have any priors, Your Honor.
All right. I'll leave the bond at $1,000 each count. If pretrial release is able to verify his address where he will be staying and living, I'll put him. Oh, we were just advised that a bond is being posted as we speak.
Okay.
All right, so
Thank you for
it's only a
your
matter of
bonds
time.
Thank you, Judge.
You're welcome. Joshua Newbold. All right, Mr. Newbold, you have 6 counts. Count 1 is grand theft, $300 to $5,000. Count 2 is grand theft, $300 to $5,000. Count 3 is fraud, uttering a false instrument. Count 4 is fraud, uttering a false instrument. Count 5 is grand theft, $300 to $5,000. And count 6 is fraud, uttering a false instrument. Mr. Afzal? All right, I find probable cause for all 6 counts. And as far as the bond is concerned, Mr. Linder?
Your Honor, I'm just going to ask that the bonds be kept in place, total of $6,000 bonds. I think that's quite reasonable considering, even with mitigation, considering his record, 2008, burglary of a structure, theft, resisting without violence. He violated probation. 2008, 6 counts of burglary of a conveyance, 2 counts of grand theft, 1 count of petty theft, violated probation, was sentenced to 364 days. 2011 out of date, resisting an officer without violence. 2009 out of date, possession of cocaine with intent to sell or deliver.
Okay.
End of record.
Mr. Farber?
Judge, he indicated that he's lived here all of his life, that he's single, he has no children, that he currently is not working, and he has no money in the bank. However, he does have family members that live here in the area. He has asked me to ask the court if the court would consider releasing him to pretrial release.
And Your Honor, I would just, and Your Honor, I would just argue, as far as mitigation, other than a few family members and that he says he can't afford it, I really don't consider that any kind of mitigation when compared to the aggravating circumstances.
What can he afford?
Judge, if the court set the bonds at $500 each, he may be able to post bond on that.
And Your Honor, I would just note, I mean, well, I'll leave in the court's discretion.
All right, I'm going to lower the bond on counts 1, 2, 3, 4, 5, and 6, each at $750. Thank you.
Thank you, Judge.
Bad in it, right? Yeah. Okay. Okay, good luck to you.
I had to come last on my
Stephen Brown?
birthday. How you doing, y'all?
Your Honor, you should, and it's not going to be in your findings, but you should have a corrected booking sheet.
Yes, I do.
It was misbooked.
It's booked as a second-degree felony, and now it's a first-degree felony.
Punishable by life, yes, Judge.
By life, so it doesn't settle for the article.
And it's the state's position that if the court orders him to be held no bond, he is absolutely, by all means, entitled to an ARC hearing and division. The state would be seeking a no bond hold at this time.
Mr. Afzal and Mr. Farberik, you want to go ahead and just have the opportunity to do this over at the division? All right. Any probable cause argument? Okay. I find probable cause for the charge. We'll go ahead and defer to the division judge for the Arthur hearing.
And Your Honor, we'd ask for an order of no victim contact.
And no victim contact.
Yeah. I know what it says there. It should be robbery fire.
And lastly is LaDana Roberts.
Your Honor, this is, well, I'll wait till she gets up.
She's at the Paul Ryan.
I'll wait till she gets up. I don't want to say anything.
Oh, okay.
Your Honor,
All right, Ms. Roberts.
this is a perfection. I have nothing additional. So she should be ROR'd on the introduction count. What I'm going to ask the court to do, this is a bit of an issue the jail was having. On your findings, Your Honor, you only have 1 count of introduction and contraband.
Yes.
What I'm going to ask is if the court would be inclined, or if the clerk writes it in, she was misbooked and added with the count of introduction to contraband, and she's already been ROR'd on that count as well. But the findings need to reflect the charges she's been booked on. It'll be corrected, even if we file the charge. It'll be corrected at the point of case filing. So I don't know if the court, if Your Honor could write in and pen on the findings, this additional count. I don't know if I'm making sense.
No.
Okay,
I'm
Your Honor, do you
sorry.
see, you see on the, if you look on your corrected booking, you should have a total of 5 counts. The 5th count being a second count. All right, well then, could you print, then you know, the clerk yesterday might not have given the judge the corrected copy. Your Honor, if I may briefly, just so you understand, so I can explain what's going on here.
Yeah, go for
When
it.
if you see the original PC affidavit, the officer forgot to make any mention of introduction of contraband into a detention facility. So what he did is he went back to the jail with a new PC with the allegations, and I'll show you right here.
I see a new probable cause affidavit. Yes, that's the one that I'm looking at.
So what happened was the jail mistakenly added in
Okay.
I'll show you the money.
So the count 2 that I have up for magistrate. Oh, you know what? You're right. I do have a. I found it. There's a lot. I'm sorry. I'm so sorry. There is count 5.
Count 2 should be ROR no PC on a factual basis.
Okay.
Count 5 because no PC ROR because she shouldn't have been booked on that to begin with. I'm just asking if the court would be inclined to just write in.
Count 5.
5 introduction no PC ROR just so when the clerk enters in the system it matches what she's been booked in jail, and our office will correct that when we make the stop decision.
All right. All right, Ms. Roberts. So as far as counts 2 and 5, the introduction of contraband into a detention facility, I'm not finding any probable cause, and I'm going to go ahead and ROR you on both of those counts. You know you have the other ones that are holding you no bond, but at least these are being taken care of for you in this fashion, okay?
Check the judge.
Good luck to you, ma'am.
Judge, if I could, I know we usually start at 1 o'clock on Fridays, but did you say that that's when we were starting, or at 1:30?
No, we're going to start at 1:30.
Okay. Thank you, Judge.
Thank you very much, sir. All right.
Let all the jails know because typically they do start at 1.
Okay. Thank you. I appreciate it. All right. We're in recess. Thank you.